Hi, Angela. I'm not going to put my camera on yet, but I am here, okay?
Okay, ready? Okay, good morning, everybody. I'd like to call this meeting to order, and we would like to recognize that this meeting is being held on the traditional territory of the Lillooet Nation. Can I have an approval of the agenda, please? Moved and seconded. Call a question, all in favor, opposed, motion carried.
Just a comment, Director Mack, when we get to item 9.7. I have a couple of items to add to that request,
Okay, so 9.7,
and I sent them.
Angela's got all that?
Yeah, and I think that's all we need to say. We'll just change it when we get there. Yeah.
Okay. Okay, we have no closed meeting. Consent agenda. Could I have an approval of that, please? Moved and seconded. Call a question, all in favor. Opposed, motion carried. Business arising from the minutes? None. Staff reports and other business. CAO verbal update.
Hi. Nothing too exciting today. I did want to note that the electric charging stations are installed at the SLRD offices. They're not active yet. And we needed to install them within the confines of the building, so they're attached to the building. The cost to install them out in the parking lot would have been
Huge.
a much bigger conversation just to get power over there.
So where are they?
Well, I can show you afterwards, but they are underneath the building where this SLRD vehicles normally park.
Oh.
So we'll figure out a schedule for that. And for interim, it won't be publicly available in the map. It'll be for staff, SLRD vehicles and directed vehicles, visitors coming.
Oh.
Yeah. So,
So right down in this corner.
Yeah, well, that's good.
yeah, it's a great move.
Especially in the winter,
Mhm.
because the range on my vehicle is just tight
Yeah.
in cold weather.
Same in the Volkswagen, going up that hill, I get down to my home, so I'm not gonna make it home. So we'll have to somehow organize a schedule, because I would need to know if we bring the Volksy down, that that's available.
Yeah, it's good. Yeah, well, we'll let you know
Okay,
when
how it works.
it's active, but it
That is fantastic news.
verbal ribbon cutting there. It was very exciting, and I want to thank the ES team for approving that idea. And then other than that, missed you all in August, was hope you all had a great break. Nice to see the emails and questions and conversations coming back in, and looking forward to this next year.
Very good. Thank you so much. Motion received. Second, call the question, all in favor, opposed, motion carried. Thank you. 7.2, request for decision, notice on title, construction contrary to building bylaw regulations, Carrigan, Nishikawa, Area C. Who's going to speak, Jay?
Morning, everyone. Jay McEwen, Chief Building Official. Harshan Dhaliwal, Building Official, is going to speak to our first report here.
Good, thank you.
Good morning. My name is Harshan Dhaliwal, and I am the building official here. So the property owner, Kerrigan family in Nishikawa, property address 2921 Birkin Lane, Electoral Area C. The building permit application was received on September 29th, 2016 for the construction of a garage. And the building permit was issued on December 19th, 2016. The last inspection conducted was a framing inspection, which was on July 4th, 2017. And a renewal package was sent for building permit renewal on November 7th, 2018. Property owners were contacted on December 20th, 2018 with a permit expiry date of January 19, 2019. Property owners were notified that without a renewal application, we will proceed with a notice on title process. We received no response from the property owner, and since the construction exists, the permit has not been completed. The staff requests that a notice on title be placed at this time.
Anything else?
Not right now, no. Any questions at all from the community?
I guess my question is, so this was in 2016, 2017, 2018, 2019. So we're 6 years down the road. It took 6 years to get to this point.
If I may, through staff are continuing through a backlog of expired building permits and notices on title to present to the EAD. So we're doing our best to go through and distribute the ones that we based on urgency for timeliness or ones that have been sitting on our shelf for a little bit too long. So we're bringing them to your attention as the agenda warrants.
Okay, so I guess my question is then, like it says, desired outcomes complete the building permit process. So are we, you want to go to a notice on title, but should we not, because of the delay in time, in my mind, should we not be trying to get this individual or individuals to bring their property up to the stuff, get this permit finalized?
So the permit's expired.
Yeah.
So we can't, by bylaw, we can't reactivate expired permits. The notice on title lives on title as a red flag or warning to potential purchasers or financiers. We can't force residents into applying for building permits. So we encourage people to bring in their properties into compliance, but we can't hold that ransom. The notice is our tool just as an awareness for the owners, potential financiers, et cetera.
So we can't just send them a letter saying, this is your final gasp at this, we need to get this done.
We did in December 2018 and January of 2019. I didn't hear anything back.
Okay.
Am I seeing, so on communication, because my question was, when was the last time that the property owner's being spoken to or contacted? And what I see is in accordance with under communication, they should be afforded an opportunity to be heard before the EAD committee decides whether or not to pass a resolution recommended in its report. So have the property owners have they had the opportunity to be heard?
So prior to presenting these reports to the AD, staff send out letters to property owners regarding the upcoming request for decision at least 30 days prior to the meeting and the presentation. So everyone today that we brought forward have been notified, and 2 of the 3 property owners have chosen to attend today's meeting.
That's it. Thank you.
Okay, any other questions? Sal?
No,
Tony?
no, I had the same question as Vivian, so thank you.
Okay, then I would suggest that what we do is we vote on option 1, the preferred option, which is file a section 57 community charter notice in the land title office with respect to the property. The property owner may apply to have the notice removed once the contravention has been resolved. So I'll make that motion. I'll second it. Okay. Moved and seconded. Call the question. All in favor? Opposed? Motion carried. Thank you. Now we go on to
7.3.
Yeah, just gonna check this off. 7.3. Request for decision, notice on title, construction contrary to bylaw, building bylaw regulations, Coggins, area C. Okay. Just let these guys speak first on.
Okay, sorry.
Subject property, a building permit application was received in late July of 2017 for a move-on mobile home. The building permit application was received. Another building permit application was received in October 16, 2017 to permit an existing accessory building. Building permit was issued in October for the move-on mobile home. The property owners were contacted in November with a list of outstanding documents for the issuance of the permit for the accessory building. Might get confusing, so I'm welcome to questions afterwards. A partial building inspection, final building inspection took place in December 2017 for the move-on mobile home. Outstanding requirements included completion of permit application for the existing accessory building as it was incomplete at the time, and a final inspection of the existing accessory building. The property owners were contacted in 2019 with a permit application expiry date, as the permit had not been issued at that point for the accessory building of July 19th, 2019. No response was received from the property owners, and as all structures exist and the permits have not been completed, staff requests that a notice on title be placed at the time on the property. The issue that exists with this and how this came to be was that the permit issued for the move-on mobile home was issued with the explicit knowledge that the accessory building as an unpermitted dwelling must be permitted as an accessory building and completed as a condition of the issuance of that other permit, as it was in contravention of both the building bylaw and the zoning bylaw at the time and currently. The zoning bylaw prohibits the number of dwellings that currently exist on the property, and staff believe that a notice on title now, again, as a flag to potential future owners and purchasers, that a contravention exists on title of the building bylaw. The notice may be removed upon application of building permits for the expired building permit for the mobile move-on and the expired application to complete the change of use from the unpermitted dwelling to an accessory building to bring it in line with the zoning bylaw.
So I've got a couple of questions. One, can you explain that move-on mobile home? Just explain what it is.
So a mobile home, not a modular, just mobile home. We issue building permits for those differently than we do a brand new stick framed building. We don't issue a regular building permit. We issue a move on because they're manufactured somewhere else and then moved onto the property within the SLRD. So whether they're new or used, that's how we deal with those as they're manufactured in a controlled facility and under a different national standard than the BC building code.
Does that mean that it gets onto some pillars or something?
Yeah.
Gets mounted onto something?
Correct, yeah, and there's a number of different ways of doing that. So depending on how it's proposed, that's how we issue those.
Would that have to be engineered?
Not necessarily, no. There's methods within the building code and within the CSA standard that allow building officials to look at and approve those siting and support systems for mobile homes.
Thank you. The other question I've got. After the property owners were contacted on January 9th, saying that the expiry date was going to be in July 9th of the same year, why wasn't explained to them about a notice on title? The previous one we just reviewed, they were told that there was going to be a notice on title. And I don't see that in here.
So in the same fashion as the previous report, the homeowners involved in this presentation were notified that a notice on title report was coming to the electoral area directors today, and they've elected to.
What I'm saying is, in the previous one, it was right after that last comment. You know, in the issues concepts, it actually said that the notice on title was going to be issued if they didn't comply.
That's a really good question. It could have been in the letter. I can look to that, but it is in the building.
What I'm looking for is something after their last expiry date, which was July 9th, 2019.
Mhm.
Was there any communication with them letting them know of the notice on title?
Let me look into that. There could have been, and it most likely would have been in that letter. We had staff use a template, which we send out.
Yeah, I'd like to
fairly
know that.
repetitive. Yeah, definitely. And it also is included in the building bylaw, so, and also within, at permit issuance. So people are aware that if, with an unfinished permit, that this is a consequence that is possible.
To me, it very similar to the one previously. You know, that's why I voted the way I did, because they were given notice quite a long time ago that, you know, if they didn't comply, there was gonna be notice on title. I just want to be consistent, and the next one is very similar, so.
Yeah, through the chair, Kim Needham, Director of Planning and Development Services. Because, you know, a lot of times our letters to applicants are so far in advance of a notice on title, it may not be said, but as the chief building official noted, we do have notes throughout our building permit process that a notice on title is a possibility if work is done without a permit. So that's that's a standard across British Columbia. It's not just something that we do. These notices happen all over the province. And it's really, as the chief building official noted, it's really just as a safety precaution for future purchasers. So people should know when they're buying a property that there's illegal construction on that property, and realtors should know, and vendors should know. And all this is a flag to potential purchasers that they might be buying something that's not to code. And these things come and go from titles. We put them on, and when the building is brought into compliance, we take them off.
And then when you say brought back to compliance, they would have to get another building permit.
Correct.
to-
Or
to-
remove a building from the property entirely if it's been brought on without permits or in violation of zoning.
Thank you.
Any other questions?
Just if putting a notice on a title, putting a notice on title on a property and removing it, that is work that staff does, and is there any cost associated to the property owner for that?
Yeah, through the chair, there is a fee associated to the property owner at the time of the notice removal, because it is work that the staff does with land titles, to have that notice removed.
May I ask what that fee is?
I believe it's $1,000.
To remove it, but not to put it on.
Correct.
Thanks.
Okay, anything else? Okay,
We don't have anything further to add.
Don, you want to,
Yes, I have a prepared statement that I'd like to read.
go ahead?
I'm here, you want me to?
Yeah, right where you are.
Okay, cool. Basically, I'll read this because I'm getting old and I don't want to miss any points. First, I want to thank you for your time and attention. There are two buildings in question here. An accessory building, also known as the cottage, was built in 1994 by the previous property owner. And a CSA Z240 standard manufactured home owned and occupied by my daughter, Catherine Matthews, and her family. The cottage was built by the Mandahogans to live in while they constructed their principal residence, as witnessed by three neighbors, namely Mike Rogers, Nancy, and Rick King. I'll read Mike's statement. Mike Rogers of 8946 Pemberton Portage Road, who resided in the address since September 93. I live next door to the Coggins property at 8930 Pemberton Portage Road. I recall and witnessed the outbuilding in question was constructed by Ron Van de Hogen in the spring of 1994 before the construction of the primary home. If you have any further questions, you can contact me. This is an open meeting. I'm not going to put his name in the email out there. If you want it, you have a copy of this. Second one is from Rick and Nancy King on the other side. We, the above mentioned, have lived next door to the Coggins property, 8930 Pemberton Portage Road, since May of 2010. To our knowledge, the cabin has been there and in use since at least that date. Should you have any questions, please feel free to contact me. And you're correct in seeing their name. Please note that after construction of the Van de Hogen's principal residence, the cottage was occupied by their daughter until we purchased the property in 2016, with the intention of allowing our daughter and family to put on a home as well. Based on the lot size bylaw number 765, 2002, section 5.1 allowed for one single family dwelling, one cottage, one second family dwelling. When we inquired as to placing the Z240 home on for our daughter, we were directed to read and interpret the building bylaws by ourselves. Please note that we additionally were told by the planner that we were allowed a second dwelling. The Matthews proceeded with the required $10,000 expenditure to gather the documents necessary to submit a building permit. The permit application was submitted July 2017. Excuse me, I have a little frog in my throat. And it was at that point we were informed that the Z240 home was considered a third dwelling. The cottage was also considered a dwelling, that the SLID was previously unaware of the cottage existence. At the time of that purchase, we had no reason to believe that At the time of the purchase, we had no reason to believe there were permitting issues or otherwise with the cottage. The real estate listing even included the exterior and exterior shots. I have detailed written account of the hoops we jumped through at the time to bring the property into compliance, but a long story short, we were unsuccessful mainly due to affordability issues. About a week before the Z24 was scheduled to move to arrive, we were told if we took out a building permit on the cottage, a move-on permit would be issued to the Z240 home. Accordingly, I took out a permit on the cottage, which is then viewed as an accessory building because we removed stuff. They were inspected. It was an accessory building. But on the permit that it was issued for the move-on, the two buildings were tied together. I was not advised that this was going to be the case. That's what happened. We had no choice because the building was coming down the driveway to sign under duress. And I thought stupidly that I'd be able to work my way through this nonsense because it is nonsense. This is the point where all parties left the playing field, if you like, and it stood that way for, well, this was in 2017, it's now 2024. Building department claims they contacted us, advised that the permits were about to expire. I do not have any recollection of that happening. I have searched my records and cannot find anything to that effect. I've been retired for 10 years, though I've never stopped working, and I have a pretty good record of maintaining things. But I have nothing on file for this. Now, for instance, when I got notice of this, it came by registered mail. I knew I got it. Recent communication with the building department revealed that they do not reopen expired permits. Please note that the SLD policy 4.9 says a new building permit will be required for building permits that have expired and more than a final inspection is required. In our situation, only the final inspection is missing on this Z240 building. So that's the only thing that needs to be done for it to be in compliance. Today, the situation is unchanged. We are still, when we have looked into how to bring this accessory building into compliance, it's about a $30,000 bill. Because we have to go to as-built, complete with basically a complete building permit for a building that already exists. It's there. It's been there since 1994, still standing, no problems. An alternative to even tear it down, it's about a $15,000 bill to take and remove everything. So we're not poor, but we're on a fixed income and a few discretionary funds besides that. But I'm not going to put $30,000 into a building that is going to be there for accessory. We have asked the SLRA to consider one of the following situations. Issue a final occupancy permit on the Z 240. As per policy 4.9, please reopen the expired permit and complete it. There's nothing left outstanding on that move on. It was all completed, 100%. Direct staff not to file a notice on land title, if you choose to do that. If you must, file a notice on the land title office, but put on the file that only accessory building is non-conforming with no further action required. And that is my ask. Quite simple. I have a few observations, but Russell, I'll be more than happy to give you a copy of this and you can read those off. Right? Thank you for the time. Is there any question?
Thanks. Tony, go ahead.
I think I just heard that we've got two buildings there, existing cottage from 94, and we've got this move on mobile. And that they're tied together in terms of permitting, and so I'm wondering why.
They were not asked, that was not asked if that would happen. When the permit showed up to move on, the two were tied together, and I had never agreed to that.
On the
Okay.
building permit, when we signed to pick up the building permit, and it was the house was on its way. We were way down the rabbit hole financially to be like, no, you can't, well, I have to pull out, but I'm gonna have to pay for a $200,000 building that I can't move onto my property. So we signed this building permit, but the building permit, they changed. What we understood is that we had to open a building permit on the accessory building, but they've written move on, permit, final inspection is subject to completion of the accessory building permit final. Now, because this is my home, but it's on their land, I didn't get to read this document. This was signed by one of them because they just had to come in and sign it. I did not get a choice at all on how this went, even though it's my money, it's my $300,000 that went into putting this move on this home. And now you guys want to make it so that I don't have any equity value left in it if you put a non-conforming on it, but it is done. I have a partial final inspection that says everything is done except for the accessory building. And they gave me occupancy of the building, but not final. Thank you.
Okay.
So the way, and forgive me, this was before my time, the way that the file reads to me was that, and this is something that the building department engages in fairly regularly, was that there was a negotiation involved that instead of flat out refusing the building permit for the move on mobile home, which it was typical and within the SRD's rights under the building and zoning bylaws, that they would allow it, as I believe it was on the way, to as a condition of that, have the property be brought into compliance with the accessory building being decommissioned from a unpermitted building entirely from a dwelling into an accessory building with a building permit so that we could have the entire property within compliance. Nothing was, the accessory building application, the permit for that was never issued, as we never received a complete application for that accessory building outside of a completed application page without any drawings or anything that we would normally require for a building permit application. And as a condition of that, in issuing under the circumstances, the homeowners didn't fulfill their end as it was offered by the building department at the time. This is kind of commonplace, as you're all aware, of how we try to work with homeowners and work with property owners in bringing their properties into compliance when they have contraventions that already exist on the property. We will sometimes offer to work with them to move their projects forward if they work backwards and bring older buildings out of compliance into compliance through the building permit process. This is one example where the homeowners did not follow through with what was asked of them by the building department.
I have a
Go ahead.
question. The accessory building in question predates the original building permit on the home. So what I'm curious is obviously the previous owner either was did not bring it on their plans, did not show that that building was there, but it's in relatively close proximity to the main home. So I'm wondering is how did the SLRD not notice it at the time of that inspection when the original house was built on the property? Because as far as we know, when we bought the property, there was nothing wrong with that cottage.
There was not any, wasn't there until we actually did a survey to bring the Z24 240 horse into the building permit for that. In fact, we were accused by the building officials at that time that we had built the cottage.
I was asked, how do I know you didn't build it?
And I'm sorry, that kind of fixed me and said, we're not gonna get any kind of a fair hearing here, so let's just move on. And I don't have $30,000 to put in to an accessory building.
Or 15 to tear it down. It
It's
sits
not
there empty.
reasonable. And when I've asked other people, Russell, pardon me, have asked building inspectors outside of this regional district, what would be required? I was told it would be a simple as-built. And that would be pretty much it. And I cannot get a response out of even the building department today, what exactly is required. So I go to an architect or a designer, I'm getting quotes of anywhere from $25,000 to $30,000, and that's out with any callback to go. It doesn't make sense.
Nice to I spoke with Mr. Coggins on the phone about a week and a half ago and told him, I can confirm that what we've asked for is simple as-built drawings to bring this building bring the building into compliance through the building permit process. As far as they're unaware, whether or not the building was permitted, we encourage all homeowners on the potential purchase to come into the SRD and review their permit history on the property prior to purchasing lands. We don't patrol real estate listings or drive through the SRD noting what is and what isn't there. We simply don't have the staff capacity to do that. The accessory building in question here was built sometime in the 1990s. We don't know. We don't have any records of it. It was built without permits. Again, the SRD didn't have the capacity then, nor does it now, to go and patrol without having a complaint by one of the neighbors lodged that illegal construction is taking place. So it's hard for us to be able to take responsibility for things that we don't know about.
I'm not asking you to take responsibility.
Just hang on a sec. Yeah, Kim, go ahead.
Yeah, thank you, Chair. And further to what the chief building official just mentioned, I'm not sure why a notice on title was not placed in 1994 or whenever that was built, but as chief building official noted, we don't patrol these things. But had a notice on title been on your title when you went to purchase, you would have known that there was illegal construction. And that is exactly the reason why we put these notices on, is so that people aren't left with these big expensive surprises.
And I don't argue with you.
Tony.
Well, that's the point I was going to make. I understand that this cottage was built around 1994 and that people lived in it while they built a house next to it. So we must have been involved in that process. We must have had at that time a building inspector that went out more than once to view that new construction, and the cottage was right next to it. It seems to me that reasonable to expect that the building department would have said, what's all that doing there? You don't have a building permit, and that should have been taken care of at that time. And it wasn't. Now, that's no fault of the people sitting here now that are now trying to clean up these things. But the fact is, it should have been dealt with in 94, and it wasn't. So that's one comment. And then the second comment I have is that I still don't understand why the two things have to be tied together. The move on mobile home, yes, we need to know that it complies with all our, if it's built somewhere else, we need to know that it meets the BC standards or our national standards. No problems with any of that, but apparently it does. And it's been approved, but we're not doing the final approval until this other problem is taken care of, which is partly a problem of our making. So I'm sorry, I'm just not comfortable moving ahead with a notice on title when I don't think we've adequately dealt with the situation.
So having said that, how do we resolve this?
Through the chair, as I just mentioned, I've had phone conversations with Mr. Coggins. We've been in touch with the family over the past 60 days, I'd say, since our first notice went out that we were going to be bringing forward this report with instructions on how to bring the property into compliance with or without notice on title. But again, this being the regional district's only tool to bring awareness of deficiencies that are on properties that are in violation of our bylaws. This is really the only option that we have to make sure that the awareness is there for, again, potential future owners, buyers. et cetera. To answer Director Rainbow's comment, we would never have issued the move on mobile permit, period, if the property was in contravention of the building bylaw in the first place. So offering that as it was already purchased and already on the way was again a tool that the building department has at their in our toolkit to work with homeowners in bringing the entire property into compliance. So the buildings were tied together, and it was written and mentioned in communications and on the building permit that the completion of the move on mobile home was going to be subject to the property being in compliance. Whether what happened 30 years prior to that, I can't speak to. Whether or not it was noticed by the building official, or where the buildings are sited in relation to one another, or what the use was at the time, it's impossible for me to say.
Go ahead, Tony.
Well, I just want to follow up on that. Yeah, this was 30 years ago. And when I look at what happens when we place a notice on title, if the owner then wants to sell the property, then that would have an effect on the price, on what the purchaser would be prepared to pay. It could have a significant effect. And when you look at this situation, we've got two buildings there. If the notice on title includes the $300,000 home and this accessory building, that will have a major impact on the value of that property. And I don't think that's fair. And I think we have, regardless of what happened 30 years ago, or 20 years ago, or 10 years ago, we do have the opportunity now, if we want to separate those two things. To look at the mobile home and make sure that is, apparently we've already made sure that it's okay. And we're just saying, well, we're not going to give the last bit until this other one's done. Now, if we remove that mobile home from the equation and give them final approval of that, then we can look at the second situation. And if we're going to put a notice on title just for that second one, then I don't think I'd argue against it. But as long as they're tied together like that, I will. I won't approve that.
So,
Can you explain the as-built and what that involves? Please.
Drawings?
Yep.
Yeah, of course. We would, in a building permit application, we would want the applicant to provide drawings as built, which translates to as the building exists. So what's there? Show us what's there. Show us the relationship to that, to the property boundaries, to other buildings, and some very basic construction details. As we've requested the building be an accessory building, it doesn't necessarily need to meet the building code requirements for a home. It can be quite simple, and the process for applying for a building permit for an accessory building and the requirements for an accessory building are much more relaxed. So likely whatever exists there, if we were to permit that as an accessory building, would be a fairly easy process as far as building permit applications are concerned.
So what would be required on the costs of all this? Building permit, of course, goes for an accessory building is on the value of it, right?
Building permit application for an accessory building is $530, and then the building permit fees are based on the declared construction value or the formula in the building.
So there have to be a land survey, certified land survey.
Yeah.
And
which I believe we probably already have from an existing, or the homeowners probably already have from an existing building permit.
architectural drawing.
Not necessarily architectural. Actually, the architectural drawings are not required. It can be just a building designer. But the drawings, or a homeowner is permitted to do them on their own as long as they show all the details that are in the SLRD's checklist, which is available on our website.
And just would you have for a small cabin, what that would cost roughly?
In my mind's eye and in our neck of the woods, it's hard for me to comment on that because it would change from designer to designer, but $30,000 doesn't necessarily seem correct in my mind. I think we'd be in closer to what we would require for a building permit application for an accessory building, maybe in the $4,000 to $6,000 range sounds a little bit more appropriate. Given the fact that a lot of the other things that would be required in that, like a legal survey, have already been completed and would be easily accessible to reproduce, so. It's not insurmountable, in my opinion, for the path forward to compliance that we've offered the homeowners. I don't think it's that difficult, in following along in our bylaws. The separation, Director Rainbow, sorry, of those two buildings, I understand your point, however, we'd still be in violation of the zoning until we can prove that that accessory building is not a dwelling as it was constructed illegally in the 90s. The zoning, Director Needham, correct me if I'm wrong, only allows for a two dwellings and an accessory building. And
So-
as it exists currently with our third building, it
Give
has
me your
three.
definition of an accessory building.
Anything that's not a house.
Okay, so it would be used then for storage or whatever, but it's not a livable space.
Not a dwelling as defined by the building code.
So, go ahead.
When we were waiting for our move-on permit, we stayed in the cottage. And part of the deal was to get the building permit is we had to move out of the cottage into my parents' house and decommission the cottage, make it a non-livable space, remove the stove, remove the plug, remove the vent. We did everything and that was inspected by the SLRD.
Right.
So we already did that. You already know that we've done that.
So
I don't know, but now I
Yeah,
do.
but they did. The SLRD came and that was part of the inspection. When my final was done or before my building permit was issued, that was checked.
And I will question one thing. We did have a conversation and it was helpful. However, what I did not get was assurance that a simple as-built, and a definition of an as-built is you have a set of designs, place is built, and then an as-built shows you any changes from that original design. There was no design on this. So an as-built is taking measurements and set it up. They also told me that I would have to open up walls. As soon as you open a wall, then it has to be brought up to code.
It's 30 years old.
That's your rules, not mine.
Not,
That's what you
If I
told
may.
me.
depending on the use, we would need to have a little bit of investigative work done. And for a drawing to be accurately representative, you might need to make a hole in the wall to see, is this a 2x6, a 2x8, or a 2x12? This is customary, and with most buildings, you'd need to open up a little bit. So in an accessory building, I didn't think that was a bridge too far to maybe open up a wall or two, not entirely, not stripping back the building, but just to investigate as to how it was properly how it was constructed, making sure it was constructed properly and safely more than anything.
If it's just an accessory building and it's just for storage, then what standards does that have to meet?
It still needs to meet the BC building code structurally to make sure that it's safe for people coming and going if they're storing
So to the
materials.
same level as a livable structure?
Well, the same level as a garage would be, so that whatever you're storing there isn't crushed under snow loads in the Birken Valley.
All right, Sal first, then Tony.
I'd like to make a motion.
Okay,
I'd like to give the proponent 6 months to review with the SLRD staff an as-built and to see if we can come to a resolution on that permit.
Tony.
Yeah,
It's
the thing I
just on this as-built, because it sounds like the quote that the proponent was looking at was quite a bit more than what seems to be required. So I'd like to give a 6 months delay on this.
I would second that. I have another comment.
Pardon
I
me?
have another comment.
Okay,
Or question, Lord, for staff to follow up. If the proponent actually went in there and took out all the livable stuff, you know, the kitchen, the bathroom, that sort of stuff, if that's been done, and if at the time the SLRD inspected it, then we should have a record somewhere to say that we know that that was done. So I'd like that to be investigated, because if we know that that's not a livable space, then I don't see why it's in contravention with the zoning. There'd only be 2 livable buildings on that site. So I understand what we're asking staff to do, to sort of go through the files and bring everything up to date and so on and so forth, and I have no problem with that. But this particular one, I think there's room for us to be a little bit more creative than we have been in solving the problem. So.
Go ahead.
I think I might have a solution. I don't. But if the permit is separated and the Z24 building is approved, because everything's done, I'm quite willing to accept a notice on title on the cottage. Just leave it there. I'm not gonna spend a lot of money on it. It's just not worth it. And it could be a notice on title, and anybody that wants to come buy that property can see it. I agree with you. If it was on both, then it's way out of line, right? Because there's nothing, whatever, in contravention on that building. The accessory building, it's been there since '94. It's been standing. It hasn't burned down. And, you know, I've survived the fire that came within 2 kilometers last year, the flood that took out half the property this year. I'm not going to spend a lot of money. And by the way, that cottage withstood the flood too, as well as both buildings, all buildings on the property. They didn't get touched.
Kim,
Thank you, Chair. I think it's important to note that when the way it works at the land title office is when you pull your title, and if there is a notice on title, the only thing that one sees is notice on title, this property may be subject to a section 56 notice. It doesn't say whether it's for a cottage, a house, a swimming pool, or whatever. It just flags that there's something there. So anyone reading the title would then know to follow up with the regional district to get a little bit more information. And it would be at that time, we would allow them to view the file and they can see all the different things going on. So the notice isn't specific to any one particular feature of the property.
But if we don't close the permit on my house, then it is non-conforming and it no longer has any value. And that's the problem here. It does not bring the negotiating value to the table that it would if it were a fully permitted and completed building. And I did everything that I was asked to do to make my home compliant. Everything within my power.
Jay,
Through the chair, just to clear up some of that, what Director Needham mentioned is right. The notice on title is on the land, not on any specific building. Staff with creative solutions to this is what got us into this problem in the first place, was trying to negotiate how to bring entirely the entire property into compliance through a creative agreement with the landowners. And finally, to your comment about that, your building as it exists retains all of its value as it can be picked up and moved to any other property that you would want.
Can't be moved. The well can't be moved. That's like $100,000 all by itself.
Which should not necessarily be affected by anything that the SLRD would do throughout the permitting process in this situation. So you're.
hey, Jay, just, bring your comments here.
Yeah, my apologies.
We have a motion.
There's a motion on the floor and it was seconded.
And it's to delay 6 months.
Delay 6 months, give time to look at the as-built portion of the permit.
So through the chair, in 6 months' time, staff bring this back to the electoral area directors if no action has been received. Is that correct?
Correct.
I think what I'm not comfortable with is these permits being tied to each other. I recognize that was a creative solution by previous staff but here we are living with it now, right? I'm more comfortable untying those 2 properties. Is that possible?
Yeah. So I was here back when all this started. And we met here with Mr. Coggins and Kim, and we came up with this idea of how to make this legitimate. The only problem I have with it is Mr. Coggins was supposed to do certain things to get it done, right? And in the meantime, that hasn't happened. So now we're here trying to figure out how to get it done. I mean, this should have been dealt with 6 or 7 years ago when we had that meeting in this room, correct? But I will agree with the motion. But what I am gonna say is this thing has to be settled to staff satisfaction and your satisfaction. So you're gonna get a 6-month sort of reprieve here. So work with staff, get it done, just a minute, please. Get it done and then we'll go from there. And hopefully staff will come back and say everything has been sorted out. The biggest problem in my mind is that extra building on the property. If that thing wasn't there, and we talked about this way back when, if that building wasn't there and you just put the new construction on the property, that would have been fine. Now, the other thing I said at the time was, how do you circumvent this thing? Subdivide your property. But that's for you to deal with. And I know there's a cost involved and all that stuff. But there are options available, right? So I think I'm going to call the question. So it's moved and seconded. Call the question. All in favor? Opposed? Motion carried.
I have one question though. When I came to the SRB and asked about how to, what I had to do, I was told I had to reopen my building permit and start over. They're not gonna open my expired permit, even though your own policies state because the only thing left is final, you should open that.
Okay, well, look, we've just passed a motion that's going to give you 6 months for your dad to work with staff and get this thing sorted out.
No, I totally understand that, but my only question is for my home, am I now in a position where I have to start all over again with a building permit? Or will you reopen my expired permit?
You'll have to talk to staff about that. I'm not the expert on building permits, believe me. So you've got your option and.
So just to be clear that I understand the motion, we have 6 months to sort all this out. The buildings remain tied together? Or is that part of the negotiation?
That's part of the negotiation. I
Yeah,
think.
part of the negotiation. Everything stays the same as it is right now. Just move forward. Figure out how to bring this thing to a reasonable close for everybody, right? We want to get this thing sorted out from our end and you want it sorted out from your end, obviously. So you've got a 6-month window to do that. Okay.
Thank you.
Thank
for
you.
your time. Thank you.
Thank you.
Okay. Thank you, everybody. Okay, we're going to 20 after, it's at 10:30, we're gonna take a 11:30. We're gonna take a 5-minute just break. So we'll go until then, and if we get this one done, I'm dandy. So 7.4. .4 is the request for decision, notice on title, construction contrary to building bylaw regulations, Davie Area A. Okay.
Thank you. So background on this report, building permit application was received in June of 2014 for a single family dwelling on Lakeview Road on Gun Lake. Building permit 10907 was issued for an SFD in August of 2015. A letter was issued to the property owner in June of 2017 stating that the permit was to expire. The owner chose to renew for an additional 2 years. Another letter was sent to the owner in January of 2018 that the renewed permit would be expiring on August 19th, 2019. No new inspections had been called for and no further renewals would be offered due to activity as per the SLRD's building bylaw. An email was sent again in June of 2019 advising that no inspections had occurred since 2016 and that the permit was due to expire. In this email, it was also offered the option of putting in a submission right into the building official if they would like to work towards a solution. A submission from the homeowner was received and the building official allowed one final renewal with the new expiry date of August 19th, 2021. A letter was sent out again on June 2021 indicating that the last inspection was August 7th, 2019 for a solid fuel appliance. The bill did not yet receive a framing inspection. The permit was set to expire in August of 21. An inspection occurred in August of 2021. A framing inspection was requested in the end of August, and an email was sent detailing documentation that was required prior to that inspection. And after that, no response was received from the property owner. And as the construction exists, the permit was not completed. It is expired. Staff requests that a notice on title be placed at this time.
Thank you.
Mr. Davey is present to the presentation as well.
Right. Any questions or?
Not yet.
No? Mr. Davey, would you like to speak to this?
Yeah, I just wanted to point out a few inconsistencies and something that I had a question on. So this request for decision is, the recommendation says that this is based on the community charter section 57, as the permit was not obtained or the inspection satisfactorily completed. The permit was obviously obtained. I'm not sure which inspection they're referring to here. If you look, I think when they say section 57 in the community charter, I believe they're referencing section 57 B, which says something was done with respect to a building or other structure, or the construction of a building or other structure that required a permit or an inspection under bylaw, regulation, or enactment referred to in paragraph above. 2 is the permit was not obtained or the inspection was not satisfactorily completed. So the permit was obtained. I guess I'm not clear on which inspection they're talking about that wasn't completed. Secondly, item 10 under the key issues, no further response was received. I did respond to the email on August 30th. I have a copy of it here. There was a request for the on-site framing review, which I sent to them in the reply. There was also a request for a TECA report that I questioned at the time because it wasn't required to get the building permit, and I didn't see why it was required after. I need a response on that, and that was the last contact I had with the SLRD. Now the previous expiry dates, I got a letter saying that the building permit was going to expire, and I requested or applied for an extension. This time, I didn't get any such letter. Otherwise, I would have made the request. They said the permit was set to expire in August 2021. I requested the framing inspection in August of 2021. I didn't get a response saying the building permit was expired. So I just, based on my verbal discussions with Jay, I thought we were working together to finish it. I know some time has 2 years has since gone by. There's other reasons for that. I'm just also confused about their number one desired outcome is to complete the building permit process. So that's what I want to do as well. I would like to move forward with option 3 to allow more time. I plan to complete the building. I think it's in everyone's best interest to complete the building. The rest, I'm just trying to answer any questions you have.
Okay,
Through the chair, section 57 of the community charter, to the proponent's question, the inspection that was not obtained or satisfied would be final inspection, which would be the SRD granting occupancy and closing the building permit. So that's what would warrant the section 57 notice on title being in there. I erred in my presentation that prior to the extension in 2018, that the building bylaw was amended in 2020, and part of that amendment no longer permitted building permits to be extended indefinitely or over and over and over again. We offered after adoption of building bylaw 1611/2020, we only offer one extension, and after that building permit is expired. As we had a number of applicants or building permit holders extending upon extension and building code sequences getting out of date and whatnot. So the board elected to put an end to that in our building bylaw adoption. So only one extension would have been offered post the adoption of the new building bylaw. So staff ultimately the desired outcome is that we want all permit holders to complete their permits and have the property in the SLRD in compliance. The remedy to this is for the proponent to apply for a new building permit and complete his building into to final inspection.
So when was it decided that only one, you said in 2020, it was decided that building permits would only be given one extension? I don't recall. Was it 2020 that you said that?
Through the chair, yeah, the new building bylaw was adopted in 2020.
2020.
Yeah.
Okay, well then, the current building, the building permit expired in 2021. That probably should have been communicated that this was a new, I didn't know that there was a new, this had been brought in 2020 about only one extent or one renewal. I'm not opposed to getting a new building permit. There's just some issues because the original building permit was based on the building code in 2012. There's going to be issues with window performance. The windows, so in the building, there are a lot of windows. Probably there's at least a dozen floor to ceiling windows that would have to be replaced, an exorbitant cost. And we're talking about a seasonal cabin because they don't meet the performance of today's requirements. It doesn't seem reasonable to me, but I'm not opposed to getting another building permit if that will solve this problem rather than getting a notice on title.
Okay.
Yeah, go right ahead.
To the proponent's comments, there's a number of different ways that we can reach compliance with the way that the BC Building Code has evolved, especially into our new 2024 edition. So comments and stresses about performance of different building envelope assemblies or fenestration products can be overcome by making it up somewhere else in the building. So staff, registered professionals, we do have creative solutions to these problems where they're building specific. So it's applying for new building permit definitely isn't, there could be costs incurred, but is definitely doable and not necessarily the end of the world or immediately cause for things to be thrown out or replaced. So there is room for creativity there for new solutions to be proposed to bring buildings into compliance with the Energy Step Code.
So that was something that wasn't communicated to me earlier too. They told me I would have to start, the building department told me I would have to restart with a whole new building permit as if I was applying under today's code, which was gonna leave problems like this.
Yeah, I'm gonna let Director Rainbow make a comment.
I wanna move option one. I think that, I've been on this board for 10 years now, and this precedes me joining this. If this were a 2-year process, I'd have more sympathy in it, but it's 10 years. And how long does it go on? So yeah, I think we should have a new building permit and get it dealt with. So I'm moving option one.
Can I just say,
Um,
if that's the case, if we want to get a new permit, do we have to put I'm willing to work and get a new permit, do we have to put the notice on title then? If we're working together to get a new permit? I'd like to preempt that action,
Well, you made a
I made a
motion.
motion.
Yeah, is there a seconder for that?
I was hoping to hear from Director Demare.
I'd vote against it, but very similar to the last one. I'd like to see a 6 month that a building permit has been issued, a new building permit. And if it hasn't, bring it back to the EAD committee.
And hold off on filing
Yeah,
Okay, so,
I'm fine with withdrawing that, if that's how we can do that, is that how we can do that?
yeah,
It wasn't
It wasn't
seconded.
seconded,
it wasn't seconded, so
it dies.
yeah,
Yeah,
guys.
that's
Okay.
fine, that's fine.
So this is a comment I'm gonna make to staff, I guess, and us. A lot of this stuff, it just seems that it's coming from when I was actually quite a bit younger, right? I mean, this stuff is old. And I know you're short-staffed and now you're just starting to catch up on all this stuff. I think what we need to be thinking about and doing is when we bring this stuff forward the first time, like now, instead of bringing it forward, going straight to notice on title, we should be going to the desired outcomes. One, complete the building permit process and give the proponent the opportunity, say, look, this is your final kick at the can. You've got to get a building permit and you've got to get this thing sorted out. Otherwise, when you come back in 6 months, the notice on title will be a given. There won't be any arguments about it. So here's the opportunity for staff and for the proponents to get this stuff cleaned up. And I know you inherited this stuff from years and years ago, right? But it's kind of hard in my mind. So we just drop it on the proponent and say, okay, you haven't done this, this, and this, and we're gonna Section 57. But let's just call time and say, okay, look, we need to get this stuff sorted out. It's to the proponent's benefit to get it sorted out. It's our benefit to get it sorted out. So here's your 6 month grace period, which Sal and Tony have both commented on. So
Yeah.
Tony, go ahead.
Well, I just think we should vote on this motion. And if we have comments about how staff are going to deal with it,
Yeah.
we go through the CAO outside of this meeting. We shouldn't be discussing with staff right now how they do their job.
Well, that's a difference of opinion. But anyways, Jay, go
It
ahead.
is a difference of opinion, but I,
We do give people notice in our expiry letters and giving people like a good heads up that your permit is going to expire and these are the outcomes if the permit isn't completed to final inspection. We give them notice again 60 days prior to these meetings so that if we had a building permit application in the 60 days leading up to this meeting, we wouldn't be presenting this to the EAD. So my one comment is that if we're kicking the can down the road, so to speak, another 6 months, I have more of these coming for every electoral area director committee meeting for the next several years. So if we're continuing that backlog by allowing 6 months at a time, 6 months at a time, 6 months at a time for all of these presentations that we're bringing forward, we're never going to get through the backlog of the things that I've inherited over the last 15, 20 years.
So,
I think the key is having, when proponents come to these meetings, that we learn a little bit more and they learn a little bit more. And to me, that's the key. We had one last year that we give a 1 year time frame, and I see that they've got a building permit now. And that's what we want to see. We want to see people finish their building permits. So having proponents that do come, they learn and we learn, and we can make the recommendation. If you're gonna bring more, that's what I'd like to see. I like to see proponents come to the meeting. The first one didn't show up. And they got notice on title. Thank you.
You have that motion seconded? From Demeter?
It was, yeah.
Who seconded it?
I don't have a second.
You don't,
for that
okay, I can
motion.
second that.
Yeah.
Yeah.
Okay, so moved and seconded?
They didn't second it.
Yeah, I understand that. Okay, any comments then? No? Moved and seconded, call the question, all in favor, opposed, motion carried. Thank you.
So to be clear, Chair, same circumstance, in 6 months, if the building department hasn't received a building permit application for this, it returns to the electoral area.
Yeah, and
Yes.
we can talk to staff about plans and take direction.
Yeah. Okay, thank you.
Thank you. Thank you.
Kind of went past our,
Well, you did good. It was good to keep.
We're having a,
yeah,
You get talking, that's the problem.
yeah. Let's take a 5-minute break.
Touch your
Recess.
toes, everyone.
Okay, call this meeting back to order. And we are on 7.5, information report, September 2024, select funds. So Colin's here, I see.
Good morning, everyone.
Hi, Jan, I saw it. And also now Suzanne is here, wonderful.
So this report is the updated information on the select fund services and balances. Before I open it up for questions, I'll just comment on an email I received this morning regarding the Area A amount for the hazardous waste testing at Gun Lake. Regarding the PILT funds, to date, we've spent $49,000, which leaves 31,000 remaining of PILT funds for this item. I know Director Demare had a question on potentially rescinding that resolution, so.
Thank you.
And yeah, I'll open up for any other questions on this report.
Vivian,
Thank you. I have one for the Area B Select Service area. I think last year I set aside $10,000 for wildfire recovery costs. One of the things we took from that fund was to pay for some pipe recovery on a Highline Road property. Are you with me? You know, the fund and that was one expense that we put against that $10,000. I don't see it showing up here on the Area B page. And I wanted,
Yeah, I
what
don't
do
see it either. I can review and see if that's missing from the report, and I can connect with you. I'm not sure off the top of my head.
No, of course not. So just sort of like sometimes other things are shown. Like we're, setting aside money for this or that, and some of it's been spent, but it's all there on the page except for that 10,000 minus at least one known expense. And I was thinking of other uses for some of that money, so thank you. Next report is soon enough.
Yeah, thank you.
well,
I'd like to make a motion. Oh, sorry.
Are we finished questions? I thought
Oh, okay.
it was just waiting until it came round to Area D.
Yeah.
Go ahead for questions, then I'll make a motion.
no,
Have you got any? I was just being polite. A, B, C, and D.
Yeah.
Okay, great. D, just a comment, first of all, thank you very much for taking care of that Jack Webster Bridge grant thing. If I understand that correctly, that $5,000 has been put back into my account. Is that what that means?
Yeah, correct.
Good,
That's
yeah,
correct.
so thanks for taking care of that. I have a question right underneath that. September EAD, Britannia Beach Parks and Trails, Sun Shelter, $2,000. Now, I'm not sure what that is or where that came from. Because further down, September EAD, Britannia Beach Parks and Trails, 3003, Sun Shelter, 13,000. I remember applying for that. Where's that 2,000 come from?
So the total resolution was 15,000, and 2,000 is the amount that's been spent that we transferred to the 3003 service, and 13,000 still remains.
Oh, so 2,000 has been spent. So the Sun Shelter, well, I won't comment on that here. Thank you.
Thanks.
anything else?
I don't think I have.
No, I got a motion. I want
Okay.
to.
I'll second it this time.
No, it just. Hold on
Just
now.
making sure.
So on the allocated, 2023 allocations committed, October EAD, asbestos testing, Gun Lake wildfire debris funding contribution. The asbestos testing, I would like that funds to go back into the uncommitted Area A select funds
Nice.
to be used in the future for other wildfire, Dalton Lake wildfire recovery efforts.
That's a question.
Yeah.
I just want to make clarification, so that would immediately stop any new submissions of asbestos.
They're still built, 31,000.
Okay, got it, perfect, thank you.
Go ahead.
Another question I forgot to ask when I was talking about that $2,000. Now that I understand that that's money that's already been spent, can I ask what it's been spent on?
Outside of this,
Yeah, I'll have to pull the invoice, but I
Outside of
can
the
connect with you on that.
Sorry, all right.
I'd like the second director's mayor's motion.
I beg your pardon.
Okay. Moved and seconded to call the question, all in favor, opposed, motion carried. Okay, Director Rainbow, go ahead.
Was I just being told this is the wrong forum for that
no,
question?
I get that, we can get that answered for you.
Okay, thank you.
Okay, any other questions or motions, or everybody satisfied with their select funds?
I'll move receipt.
Yeah. Moved and seconded.
Yeah.
Call the question, all in favor, opposed, motion carried. Now we go to 7.6. And who
And I'll,
is gonna speak to this?
Oh, the Heritage Service.
Suzanne, if you're, Kim was going to be your case for questions.
Do you want to speak to this, Suzanne?
yeah, I'll wait until Alex shows up. Alex is coming in to support the projects. But
Okay.
basically, this report was referred from the board to the EAD committee for their opinions on the taxation type that these services will use. So because these services have a combined projects, two with a small third project for signage, these two projects are going to be divided out amongst the Area A to Area D heritage services. And so these three scenarios in the report are to help the EAD pick one of the scenarios they want for taxation for these services. So the options are via, the requisition-based taxes using a uniform tax rate, requisition-based taxes dividing the costs evenly amongst each area. This does cause varying tax rates for each service, so it's not recommended. And then the third scenario is a parcel-based tax requisition, which taxes every parcel the same, whether it's improved or not. This recommendation for this report is to go with scenario 1, which is a requisition-based taxation using a uniform tax rate for each service. So each service area will pay the same amount. So I'll just refer it back to the EAD for what they believe would be the best method for cost recovery.
So
I've got a question on, there's a 2025 and a 2026. Maybe we can get an explanation of the project for 2025 and the project for 2026.
Yeah, there's basic information for 2025 within the report. It's developing a strategic plan. And for more details, I'll refer to Alex for that one.
Sure, thank you through the chair. So as Suzanne mentioned, the first project that's identified as the strategic plan. So that's really the high level guiding document that would guide how heritage is being managed across the regional district in in all of the electoral areas. We envision that as being unique to each electoral area, but also setting kind of a guideline or setting up a framework for how it will be approached by staff across all departments in the regional district moving forward. There's a great example of a similar project that was just completed by the district of Squamish, which is their heritage management plan. So that's the strategic overarching document. The second one, which is that's the heritage inventory. And so the heritage inventory is a listing of all of the potential, or sorry, rather all of the heritage assets across the regional district. So thinking of that a little bit more broadly than potentially just built infrastructure buildings, there could also be cultural landscapes, there may be trails, there could be things like culturally modified trees. And really it's important, I guess, with considering both of these projects, one of the really important components is setting up opportunities for potential partnerships with both First Nations communities and First Nations governments. So really developing that clear understanding of what the historical land use patterns are. So the strategic plan can contain recommendations for how those partnerships could be carried out. The inventory will look at the historical land use patterns and potentially things like archaeological sites where that's publicly available information that can be shared. So I'll leave it there. If you have other questions, I'm happy to provide more detail.
Thank you. Thanks for this. I at the board meeting also mentioned I have a lot of problems with this entire proposal. So you sort of answered one of my questions, because when I see heritage, I go, whose heritage are we talking about here? And it seemed to me that we were talking about colonial heritage here. And at least in area B, most of that is pretty much burned to the ground or is on private property. Where we have a lot of heritage is there's a lot of First Nation sites that are pretty interesting, but I would like the lead on that to be from the First Nations, certainly not from the SLRD. The only asset I see listed here in B is the former self-supporting Japanese internment camp. I didn't even know this was there at McGilvery Falls. I sort of did, but I don't know all that it exists of. If there's a draft inventory of heritage sites, it's already been done as referenced in the report. I definitely need to see that. I really need to be convinced that this is something we want to start taxing people for. And even though the payment sort of schemes that are here, the way that different tax, I know area B benefits from it and I appreciate that, but at this point, I'm not in as far as area B goes. I would need to see that there's a reference to substantial heritage assets, and so I'd like to see that draft inventory that we apparently already have. That's the first thing.
Can I help with that one?
Yep.
Through the chair, I requested that examples be included in the report first came to me. There's not a robust draft that would be almost data informed decision making, to be honest, but I wanted some examples there. And with the conversation about First Nations, that is definitely a lead. The First Nations are taking a lead on that. What we want to not do is ignore it. So when we talk about heritage, we want to recognize that we're here to support if the nations would like that support. We're not taking a lead on their heritage, especially because many sites they keep to themselves purposefully and rightfully. And then as I just wanted to clarify through Angela, one thing, which was it looks to me as if the motion to tax has been passed. It's how we tax it? No? Okay, thanks. So then we're still you're at the right spot.
I wouldn't have supported that motion because I'm pretty strong on this one.
Same here. My first question is, where did this initiative come from? And I'm sort of thinking back to the discussion at the board meeting. I didn't think this was a huge topic. I thought this was something relatively simple. So when I read this now, I'm thinking, how much time is going to be required? What is the priority for this project? And who determined that priority? Because I'm not comfortable with spending tons of staff time on this, quite frankly. But it's if I look at area D, we had a situation without any kind of strategic plans or anything. We had a situation emerge where a landowner asked that certain buildings be declared as heritage buildings. It went to planning, there was a rationale for it, it got dealt with, and those buildings are now all on our heritage registry. What's wrong with that approach? As if we identify something, then deal with it. I'm just, this is growing like topsy, and I wouldn't feel comfortable going out into the Area D community saying, we're going to add to your taxes to pay for this. Sorry.
And I feel the same way, Tony. It's just, yeah. Yeah.
One of the things when we put these into the budgets, so we all had our own heritage budgets. One of the things that we agreed upon was that each individual area could fund it through whether it's bill funding or select funds.
Yeah.
And it didn't have to go to taxation. I guess each one could do their own. I look at the Minto site that we're talking about there, and me and Ms. McKay have worked through that, and I've collected photos and you name it, because there's nothing there really. We talked about a sign. I went and looked at the Japanese.
You did?
Yes, I did, to the area there on Highway 12. And that's amazing.
Yes.
It's amazing what they did there.
Yeah.
And to have something like that at Minto, not to that extent, would be beneficial. And I'm willing to fund that. But I think the strategy, we do need to have an SLRD strategy on heritage. I think that is, but to your point, where does it sit on our priority list?
Maybe.
So did this come forward because this was something that was asked by a board at some point? And is this on the follow-up action list? Or has this just risen to staff have found time to do this at this point? Is that why it's come now? Because I didn't really see the impetus for it.
Yeah, it's a good, I'm gonna, because we have staff here.
We can ask.
This is not 2 hours of work. This, I had no idea.
I think it was if I'm not, I think it includes consultants doing the work, but still work for staff.
Alex, do you want to expand on this?
Yes, thank you. So through the chair, I'm just pulling up, there was a September 2022 report that came forward to both the EAD and the board. And that was covering, it was essentially an overview of all of the heritage conservation tools and the overall approach to heritage resource management that could be applied across the SLRD. And in that report, there was a recommendation that was passed as a resolution that the board directs staff to research and identify potential grant funding sources for the development of an SLRD heritage strategic plan. So it's coming partially out of that. I think that when staff looked at the Japanese Canadian historic sites and that recommendation to add those to our community heritage register and how heritage has been worked on over the years across the SLRD, it really, I would say, with land use planning, so planning and development services, and then the trails and parks work that we do, that's really where it's most applicable. But there's a lot of work that's been done that's kind of piecemeal and isn't necessarily consistent. We have that partial inventory that was created. We don't have always an excellent understanding of the traditional land use and those ties to First Nations. So I think essentially it was identified as a gap. It would make it much easier for staff to work consistently to apply a consistent methodology to heritage resource management across the SLRD and across all of the electoral areas. It is, as you state, a significant amount of staff time that would need to go into it. The budgets that you see before you in the report that Suzanne's put together, those are for hiring an external consultant to do the work. And I think they would also currently include a significant amount of community engagement being done either virtually or in person in those budget numbers. Hopefully I've answered your question, but happy to expand if needed.
We've recently, Lillooet, the district of Lillooet has a Miyazaki house from Miyazaki House. And the site that Sal referenced on Area 12, and I live just above the site of the internment, which is now Airport Gardens, which is now defunct, so it's essentially just land there with no sort of sign. There is some information about it, but the Japanese Canadian Society has been very active working with Lillooet community members and some of the Japanese folks in Lillooet, getting some of those projects, recognizing those places and celebrating them and providing education. And I actually haven't been asked to contribute, probably partly because they're not in Area B, but I would in Area B. I mean, I'm certainly interested in this one on Anderson Lake, for example, but I think payment in lieu of taxes money is an easy way to do a somewhat piecemeal and it respond to something that the community might ask, and that would go for anyone from the community, including First Nations. I'd be delighted to help on those as they come forward. I just don't feel, I've spent quite a bit of time. I've got this Lillooet Fraser Heritage Resource Study. You know, there's a whole heritage conservation branch. Like, I do believe there are people that do work on this and that are interested in preserving some of, their particular versions of heritage of the world, and that's okay. I'm not sure that we want to take this sort of top-down approach that's being described here in this report. Okay.
Yeah, when I read this, I was thinking around Area D. What can I see being added to here? No, there's one thing, on the rocks just near Ferry Creek, there are some petroglyphs. But I don't want any signs pointed to them. The nation doesn't want any signs pointed to them. Some people know about it, and they go out in their kayaks or their rowboats, and they go and have a look at them. And they're generally respectful. But the minute you start saying this way to the petroglyphs, then there'll be some graffiti for sure. So is it a heritage site? Yes. There's another heritage site which technically, I don't know if it's in Area D or comes under the Islands Trust, but the Defence Islands, that's a burial ground for the Squamish Nation. Lots of people know about that, but I don't think it's something you want to encourage people. Listing that as heritage, then maybe you get people going over there that are not going there at the moment. They shouldn't be going there. At Britannia, there's an old custom house. Now, there's something that at some point, there's already some talk with groups in Britannia about obtaining tenure for that and preserving it. And if that goes ahead, then there would be an application to us to declare that as a heritage building. And so we deal with it when that happens. I just don't, I can't really support the kind of money we're talking about here.
I only just want to clarify through the chair that any conversation about First Nations is not our lead. It's not within the purview of this. It's not ignoring it, which is within the purview of it. Similar to what Chair Birch Jones said, which was, should the nations require support, ask for support, or want to take part, we're here to listen. I just want to be really clear about that.
So
I don't want to come this back to the board.
Yeah, I support the coming up with a strategy for the heritage, that first one. And but for the second project, I think we can do that individually as required. And looking at the proposal and in option one, if we go with option one, it's for a 500 $500,000 building, it's 822, so $1 million would be $16.44. Which I could go for. But only for 2025 project, which would be created a strategic plan for heritage. Because I think as a region, we need to have something, which we don't have right now. We've got a lot of heritage in our areas, whether it's trails, I mean, the list goes on.
Yeah, I guess my concern is adding more taxation, however minimal, to our taxpayers, because I guarantee you, we add this one and there'll be another one and another one. And by the time next year's taxation rolls around, people's taxes are going to go up. And I just think people are just taxed beyond belief now and are having trouble. Go ahead.
Well, maybe I'll ask Ms. McKay, have you looked at any grants?
Yes, so thank you through the chair. We have started to look at potential grant funding for this. I would say in general, when it comes to heritage conservation planning and management, the majority of the grants are focused on capital projects. So there's some examples in Area A where that funding has been applied for capital projects. There's pretty limited grant funding available when it comes to creating these strategic documents or planning documents. So we might be looking in the neighborhood of, I would say, between $5,000 and really ballpark $5,000 and $15,000, something like that might be available for this, unless we're able to find other grant funding that we haven't come across so far in our search. Thank you.
Yeah, thank you. It's interesting because the only two areas are with Northern Development Initiative Trust. So they're probably funded through that program for Area A and Area B.
Probably.
With some of the heritage.
Mm-hmm.
Yeah, but then that leaves Area C and D out of it.
Which is fine.
So
That's fine.
no, what I'm saying is for the strategic plan, we want a strategic plan for the whole of the SLRD. So I'm just, if you're still looking for grants, and listen to the conversation, I think we continue looking for grants. Somewhere there's got to be something. Vancouver Foundation or.
If you're talking about a strategic plan, we're not getting into any specifics for any particular area. If you want to develop a strategic plan for area A and B, it'd be relatively easy to apply that to C and D as well. I'm just not interested in funding it. I'll pay for things in area D as they come up. I'll find a way through select or whatever to pay for it, or the proponents can pay for it.
And as Mr. Kay just said, there are grants quite not that difficult to access for the actual capital project. So I'm pretty impressed with the money that they managed to obtain, for example, the Miyazaki House in Lillooet. I think that's wonderful. And I probably will put some money in towards supporting that, because that's wonderful for all of us. But I mean, I would support, as it said earlier in the report, a grant, seeking grant funding to do an inventory I'd like to see the inventory that we have. And I feel like I don't have enough information to make a decision, and certainly to get more information on like what kind of heritage sites staff are thinking about, then I would have a better idea of whether I was supportive, but I'm pretty sure I'm not. I just run into the fact that most of our, what I consider to be sort of heritage buildings in Area B have already burnt down. They're on private property, or they're First Nation sites, which is not where we should be straying. I just.
If I were tasked with listing potential heritage sites in Area D, then I would go to each of the little communities in my area and ask them that question. What is there around your neighborhood, around your house, that you consider to be heritage, that we should preserve in some way. And then I could come back and give that information to staff. I don't need a consultant to do that. I don't want to pay for that. I'm prepared to do the work, but I don't want to pay for it.
Suzanne, do you want to add anything to this?
Yes, please. Thank you. Through the chair, very interesting conversation and something that I wasn't aware of, that you wanted to have 100% grant funded. And we can do that. We can recommend to the board that these projects are only going to be grant funded and not taxed on. And we can then put a pin in them until we have the grant funding available. My understanding was these service establishments were done in order to do these projects, not thinking that it wasn't something to do right away. So I wasn't sure. I didn't know that this could wait. It was those service establishments happened last year, or they were just approved. That's right. So yeah, basically, I think if the EAD wishes to recommend to the board that these will only be grant funded options, and then they'll wait for grant funding to be available. And if grant funding isn't available in a couple of years, we'll be bringing it back. But that's my recommendation.
Alex?
Thank you. Just to add on to what Suzanne just said and through the chair, I do want to acknowledge that in most cases where we're applying for grant funding, there typically is an expectation that some funding is coming from the organization that's applying. It may be in-kind staff time, but in almost every case I've seen, there wouldn't be 100% grant funding. There would be some expectation of a contribution coming from the regional district as well. Thank you.
Thank you.
So in that case, would we like to consider that at the board level, if there's some wish to contribute some general government funds and to be available as matching funds for grant applications? We could talk about that at the board. Or are we trying to restrict this just to electoral areas, and so not a matter for a discussion at the board? Is that second statement closer to true?
I think this was referred to us, but I don't think we're delegated.
We talked about it at the board. Yep.
But I don't think we have the authority to just go ahead and do things. We've got to make a recommendation to the board, I believe.
Well, I think that somebody should take Suzanne's motion and move it forward.
What did Suzanne say? Tell me what Suzanne said.
Through the chair, that it be recommended to the board that projects, as outlined in the staff report, are only funded through grants, with options to supplement through amenity funds if there are matching requirements.
I'll move that.
Something to that.
Okay, move, seconded.
Sure.
Okay, call the question, all in favor, opposed, motion carried. Thank you very much, Suzanne.
While Alex is here, I would just like to say that
Yeah.
I certainly appreciate the work that has been done on this. And even though we don't agree with the way forward, if you like, and I do appreciate the work that Alex and Suzanne have done on it, so thank you.
I still would like to see the entire heritage inventory that we have so far.
Yeah. And Miss McKay, I've got more pictures. Tomato City.
Excellent,
And
thank you.
Where the mine
Oh,
is.
that's completely
Yeah.
fascinating.
Okay,
Yay, 7 points.
thank you.
What to say about this one? Where is it?
Okay, 7.7 is request for decision, Canada Community Building Fund, previous gas tax fund, Community Works Fund, project funding request. That it be recommended to the regional board that $10,039 be allocated to the Divine Water Service, CC 2700, from Area C Community Works Funds towards the replacement of the solar power reservoir monitoring system. And I will make that recommendation.
Second.
Moved and seconded, call the question, all in favor, opposed, motion carried. Thank you very much. 7.8. Seven point eight is a direction request agricultural land trust to provide direction with respect to the concept of further exploring the potential of a service establishment to create a region-wide agricultural land trust. Are you going to speak to this, Kim?
Sure. Kim Needham, Director of Planning and Development Services. This report was presented in the past to the Committee of the Whole in June. And at that time, it was suggested it be referred to the Electoral Area Directors Committee for further discussion. So the options in this report are basically to give staff direction as to the desired next steps. This can include requesting staff to identify funding or a grant funding program to undertake a feasibility study to review next steps, timelines, budgets, costs, service area participants, a governance model, could involve requesting staff to prepare a report outlining a potential service establishment concept and costs, which could also be included in a feasibility study. Could also include requesting staff to bring this information to another Committee of the Whole meeting to determine the service participants and to have further discussion. Option 2 could be to request further information, and option 3, other as per the board or EAD decision. I also attached to the report the previous presentation that was brought to the Committee of the Whole outlining the concepts of an agricultural land trust.
Solid.
Thank you for bringing this forward again. And the very last sentence and key information, note that any new work on this project will need to be budgeted for and included in the 2025 board strategic priorities and then prioritized on staff work plan. So I like that. So yeah, I'm good with option 1, so I'll let everybody else talk first.
Tony.
Yeah, I just want to clarify, we are going to make a recommendation to the board on this. Yes, okay. So therefore, it's going to come up on a board agenda, and we're going to have an opportunity to talk more about it. So what I would like, I see the sentence in this could include, and then some things that. So I'd like us to talk about what we would like staff to include, and then build that into our recommendation. This for me has a far higher it has a high priority. I'll just leave it at that. I think that as we move forward, we need to take some leadership. We need to really sort of champion the cause of agriculture. It's not something we can sort of sit by and hope other people are going to take care of it. I don't think we've done enough. I think we need to do more. This is something that I would really strongly support. So with regard to what the next steps are and timelines, I'd like staff to suggest a timeline to come up with some estimated costs. And well, yeah, and to bring a more sort of complete recommended course of action when it comes to the board. But basically, I would support option 1.
Yeah, it's my concern when I read all this. I think the thing as we move forward, we want to make sure that we have the agricultural community's input into this.
Yeah.
That it's not just us sitting around this table making recommendations on how to be a farmer, because we're not farmers. The folks out there that are farming are farmers. We need to have, say, our AAC or your AAC, we need to have their input into how we go forward, and so that we don't add more rules and regulations already on top of the ALC or ALC, let's say. Yeah, we just don't want to be adding more bureaucracy to folks out there that are actually doing the farming. I mean, I totally agree that we need to enhance their ability to do their business in any way possible, because the prices of doing that business are totally out of hand. Like, it's impossible for people to get into that business unless you inherit the business. So I will also agree with option one.
Yeah, I don't think in any way we're telling farmers what they need to do and what they don't need to do. If someone's actively farming, that's great. You know, I think what this whole approach would support some of the work that, say, Squamish Can are doing to help increase the number of community gardens, greenhouses. This whole idea of allotments. There's tons of land in this region that's not in the ALR. That's just sitting there. It could be used for agricultural purposes. You know, I just didn't. I won't go on, but there. So if this initiative helps identify pieces of land and helps somebody somehow to bring that land into production, that's the kind of leadership that we should be providing. I wouldn't for 1 minute think about going to a farmer and saying, you should be doing this on this field and not that. That's none of our business at all. But if we got somebody that has, like I was talking to a landowner the other day and suggested to him that this big chunk of land he's got, that he could find someone to farm it. How would I do that? Well, you contact Crystal Tembrink and young agrarians, and oh, that sounds like a good idea. We had no idea about that sort of thing existed. Now, what might happen there, I mean, it's a long road ahead, but what might happen is that land that's just sitting there right now, that he hasn't got the time to do anything with, will be farmed. And those are the kinds of things I think we should be doing. And this, I think, is a vehicle to use to help us do those things.
Stop.
It's the very last sentence in option one is request staff to bring this to another committee of the whole meeting to determine service participants. And that's where we can get the agricultural committees involved in that. And the other one that I look at is the service establishments and bylaws. It'll be very similar to what we just discussed. Is in area A, we've got very little land for agriculture. It's all underwater into the Carpenter Reservoir right now. That's where all the good land was. It's gone. So when we start looking at very similar to what Director Bert Jones was saying, well, I don't have any heritage. So when we look at the taxation for it, how is that going to happen? But it's good to get this started and move forward. Lots of questions will be asked when it's brought back.
Just a comment, there's a lot of heritage in Area B. I just don't see any sites that I know of that are appropriate for an SLRD funded service. And believe me, I've thought about it quite a bit. I really like the idea of consulting with the agricultural advisory committees in Area B, Area C, and also climate action, or what's the CAN?
We've got staff involved in an ag plan in Area D as well.
So there you go, that covers the whole region, and so I think that would be great to consult with those three groups before it comes back to us again. When I read this, I think, oh, we should be doing this to protect lands that are really key biodiversity areas. We should be protecting lands for conservation. Okay, I don't know how well that would be received by the rest of the board members, but it's just something to consider before we talk about it again. Because we do have some key primo habitats that we could have a hand in protecting here. But just speaking of agriculture, even though in Area B, we have a lot of agricultural land that isn't being worked, we're short of farmers. I still like this idea because of the long-term benefit that it could provide, so I'm keen on this. I think it shows responsible forethought on the part of the regional districts.
So we'll move option one forward then,
With the addition of
moved and seconded. With the addition of,
consulting with the agricultural advisory committees and the
I
collective.
thought that was, I thought that was kind of,
Is that sort of included already, Ms. Needham, do you think?
not specifically, I don't think.
Not specifically. It's covered under other.
Yeah, so under other, we should just put down the three AHC groups in areas B, C, and D.
Pretty sure they'd
For
be
their input.
supportive, but they might have some great ideas and they might even be aware of other resources too. And there's really a lot, there's definitely a lot of grants that are available to support this kind of thing.
Okay, so moved and seconded. All the question, all in favor, opposed, motion carried.
None.
Thank you very much. And now we will recess for lunch.
oh, excellent. And thank Didn't hear an alarm this time either.
Okay, thank you very much. We'll get this meeting back under order here. 7.9. Information report, follow-up on request for funding, Gold Ridge Fire Protection Society. Hey, hello.
Hello,
How are you?
I'm good, thank you. Gail Harris, Legislative Coordinator. I'm just here to bring the information report for the consideration of the remaining request for funds for the Goldbridge Fire Protection Society from their original $10,000 ask. They were granted $4,000 in November, and with consideration of the remaining $6,000 to be bought after the Fire Services Protection report. The Fire Services Review, was presented in July.
Sal.
I'd like to make a motion to approve the $6,000 with the financial contribution agreement as presented in the information report.
Very good.
Second that?
My only question was that, or had that all that been approved? I wasn't quite sure, but it is all in order. Everything's all in order. Yeah.
Very good. So it's moved and seconded. I call the question. All in favor? Opposed? Motion carried. Thank you very much.
I shouldn't put my hand up at all.
That was easy. Thank you.
Yeah, we just put our hand up and
Thank you.
we're opposed, right? Okay. Thank
Yes.
you.
That's a Squamish thing. They're trying to. I guess they put their hand up for everything at their meetings. Number 8, 8.1, Furry Creek Trails, Director Rainbow. That funding of $3,000 be granted to Furry Creek Community Association from EAD select funds for the purpose of maintenance and improvement of trails in the community.
Do I need to add anything to that?
I can support this.
Yeah. I said who the check goes to, that's good. So I'm moving, who's moving? I'm moving it.
Yeah.
And I'm seconding.
You are.
Yeah, thank you.
Okay, moved and seconded. Call the question. All in favor? Opposed? Motion carried. 8.2, Scholars Library and Britannia Beach Mine Museum. Director Rainbow. That funding of $25,000 be granted to the Britannia Mine Museum from EAD select funds, contingent upon the Squamish Public Library and Britannia Mine Museum entering into an agreement for the site preparation construction required to install and operate library lockers on mining museum property. Tony.
Okay, I think, I hope that report is fairly is thorough enough to have answered your questions. So, as I've said, I just want the money approved at this point, so that when I go to the meeting with the library board, I can, instead of saying to them, I will try, I can say to them, this money is approved. If you go ahead with the project, you'll get the money. So at that point, so this money would go to the mining museum, and they're going to for concrete slab, construct a shelter that will be tied into one of their existing buildings and painted so it all looks the same. It's on mining museum property. Has access to the parking lot, so it's got 24/7 access. These lockers are not, it's a sophisticated locker system. It's not just lockers with a key. They have to have power. They have to have hardwired Wi-Fi. So the museum's providing all that within this $25,000. Well, it's going to cost them a little bit more, but they're looking after them. So where does that take us? The library, they gave the library director sort of authority to go ahead and start trying to plan this and to check out the feasibility, which is what brought her to me initially. Could I find a site in Britannia that would work for them? And now what she has to do is go back to the board and say, this is the work we've done, this is what we've discovered, this is what the cost is. She has a budget. And then it will just be a question of how much of the total cost of the library board prepared to put into it. Given the 25,000, they might pay for the rest of it. Or they might say, we still need another 10,000 or something like that. I'm not sure how that discussion will go. What I'm looking at in the next month or two is if they go ahead and say, we're going to do it, then I likely come back to EAD initially and rescind this motion and get it changed to amenity funds. But I knew if I came to amenity funds right now, it has to be referred to the board, and the board meeting is not until after the library meeting. So that's where we're at with that. Also, if they need more money, say there was another $20,000 needed for the capital expense that the libraries, and they asked for some more, then I would go to Armand at that point and ask that be the joint fund, the joint Southern Pilt that is shared between Squamish and Area D, and ask him to support that, which would go direct to a board meeting. So one way or another, I want to get this library service up and running in Britannia. I announced at a town hall meeting I had recently a little throwaway at the end of my sort of comments. I said, oh, by the way, we just had a meeting with the library people and the museum. And I said, what we're looking to do is install some, and boy, heads popped up and we almost got a standing ovation for it. They were really enthusiastic about having this. So I feel very positive about it. And I will, the next EAD, I'll be able to tell you what happened at the library board.
Right on. Good for you.
So there we are.
Well done.
So moved and seconded?
I just got one question before. Just curious on the building or the structure, whatever it's gonna look like. Is it gonna require a building permit?
No,
No?
no,
So quite small?
no. It could be huge. It still wouldn't require a building permit because it's on the mining museum
It's on
property
federal land.
and comes under the Mines Act,
Oh,
and we can't interfere with that. Now, next to this installation, there's a cottage which is also on mining property. And our long-term plan is to try to modify the inside of that so it can become part of the library outreach program. So if they want to offer kids program, parents and children, that sort of thing, they have a place to do it. And the library have the museum has a collection of mining textbooks, which apparently are extraordinary. And they want to house them in that building and have that as a reference library for university students to come to use. So that's the long-term thing. And again, because it's on mining property, they can basically do what they want. But their attitude towards working on that would be, their manager, he was saying, we would consult with Jay. We would ask Jay to come in and give us some ideas and to make sure that we don't make any stupid mistakes. So they don't need to apply to us for permits, that they would want to get Jay's expertise, which I see as very positive. So, but that's not going to happen for a couple of years, I would think.
No, it's interesting and looking in the future once, if the other project goes farther south there at Tiger Bay, if it ever goes, you're gonna have a lot more population, right? And just thought about the library service there.
Yeah, we're looking at longer term. Yeah, we want to establish. I say we. I'm a bit of a library nut, and I've been talking to the library for some time about this, and I would like to see this satellite service established and run, and it will serve Ferry Creek as well. It's not, it's in Britannia, but Ferry Creek residents can use it. And the, actually, once it's up and running, because I'm really confident it will go ahead. Anytime you guys are around, you should go and take a look at it, because there's no reason why you couldn't have a similar kind of thing. I don't know what
Well,
you've
we've
got.
got a library.
Oh, you've got the library, haven't you? So you don't need it. Okay. But Squamish Library is looking at putting one of these locker systems in Brenham Park and maybe doing another one in Brackendale. So it's not just outside of Squamish. They're looking at within their community of making it easier for people to access.
Yeah, the technology today, you're able to do all that.
That's right. The way this works is that you go online, you order a book, and then when it's delivered, and the library will be responsible for all of that operational cost. When it's delivered and placed in the box, you get an email saying your book is here, it's in box number 10. So you go down there with your library card, you open the box, and when you open the box, that automatically checks out that book to you. And then when you've finished with the book, there's going to be a return locker there. You just pop it in there.
Awesome.
Yeah.
Right on. Okay, moved and seconded. Call the question, all in favor, opposed, motion carried.
Oh, no, I'm in favor.
Me too. Bravo for the
There we go.
library.
So thank you very much for that support and for those comments. I appreciate it.
8.3, extension of subsidized tipping fees for fire smart activities. Director Birch Jones.
I was getting all ready for the wrong item next. Give me 1 second. Yes. I would like to move now. Where am I now? We've had a late request to add 2 more items to that request, so.
Not that one. This is about the tipping.
Oh, I'm sorry, we're on the tipping fee.
Yeah.
I really got lost.
8.3.
That's okay, gotcha.
Extension of the subsidized tipping fees, right, because I learned that our program funded through FireSmart expired at the end of August. However, a lot of folks in our area will be doing a lot of fire smarting during September and October. And so I wanted to contribute some Area B funds to subsidize those tipping fees for those 2 months at the Lillooet landfill. And Omar was helpful in telling me we want to exclude the commercial clients. This is just for residential clients. And so hopefully that's clear. Did you have a question?
Yes, I do, yeah. Just curious. I thought like the forest debris stuff was free, correct?
And is it related to fire smarting? It has been free over the summer as part of the program, the Fire Smart program, but that ends as of the end of August. So all of a sudden you will be charged.
Really?
Yeah. I need to find
Because
the list.
at the Goldbridge transfer station, the forest debris is free year round.
Tony.
Okay, we have a situation at Ferry Creek where there's real fire smarting push this year. And I got a request that we move in a bin for the debris to be thrown into. We have it there in the spring and the fall, but not usually during the summer. So I asked staff if that could happen. It happened, and I'm pretty sure that I got a note from staff saying there was money from the FireSmart account that paid for it. I think so, but because I was prepared to pay for it at a select, but it must have come from that. So anyway, I would fully support this. And when you say there's a FireSmart program that ends at the end of August, I wasn't aware that was the case. So.
Oh, good. Thank you.
There's Omar.
Omar's here to
Trying
save
to
you.
find my paper.
He's here to save you.
Here's my on here.
Omar,
Yes.
he's like
Stuff
that.
that I've
He's been
been
watching television. He's been,
That's why I missed some of
Well, the
I missed a bit.
I missed some of your bit, but in Lillooet, we do charge for the brush normally, other than the Fire Smart program, because there is a cost of dealing with it. We chip it and it's added to compost, and in Goldbridge, we have a burn pile, so it's a lot easier to deal with, but
Okay,
You burn it in Goldbridge.
and that's also why there's a limitation to how much we can accept. Because it's the same thing as the permit with the province, that anyone could have a burn permit. And there's levels to it, there's sizes have to be maintained.
Well, that CO2 gas is going in the
I
air.
know.
Jeez.
There's better ways, but there's also expediency, right? And also avoiding creating another fire hazard.
Fire chipper.
no, okay, I'm good with that. You know, even I got a bin for the Marshall Valley route too, right? And that worked out pretty good, and so that's 2 years in a row. The first one was funded through Fire Smart. And this year that funding went to La Joya Lake area residents. So I funded one for Marshall Valley because they like that program.
So
It's all good.
My comment was gonna be that I support this, but would like to check that there is no more Fire Smart money available, because
well, I do understand that for communities that are identified as high risk, and I don't know how we could be identified any other way. That there's an extra $100,000 fund through Fire Smart that can be applied for, but I just assumed staff would have already looked into that if it was a possibility, or not,
So a question for.
promote probably.
I could probably provide some, there is a report coming to the board about Fire Smart project for next year, and it's a $600,000 project, so above and beyond the 100,000, we are seeking a lot more funding to support that. I've asked about the discrepancy in timeline with Furry Creek's project versus the Lillooet landfill one. I believe it's just project by design based when it's submitted to the grant funder. This is the design that was done. Whereas there's a whole program at the Lillooet landfill. This is a one-off project.
Mhm.
So probably the timeline for disposal is different, but I can get confirmation and let you know. Outside of this.
So can we pass this sort of with the request that we check out if there is more Fire Smart money available? And if there is, it should be used?
We have checked that, as I
Oh, you've
understand.
checked
Yeah.
it? Oh, okay.
We
For this current year, though, this is just to cover a bit of a gap.
Yeah, okay.
And, maybe we'll do better next year. But in the interim, what I wanted to commit was up to $6,000 towards the costs of fire smarting debris, tipping fees at the Lillooet landfill for areas A, B, and the district of Lillooet, excluding commercial. Right? And I'm hoping, well, I'll be curious, I would really love to see a tally of how that money sort of was used up. Because I assume it's gonna have to be tracked anyway, and I know we're just doing our best estimate with $3,000 a month. And to me, that's really worth the cost. Of course, we don't do this, and people will probably wind up just dumping it somewhere in area B anyway, so it's somewhat of a self-protection measure. But I do know that people are very actively fire smarting, and I want to continue to encourage that.
Through the chair, I do want to say that the numbers this year compared to last year are impressive. And I think every area should be proud of the participation that's happening in Fire Smart. And the report will be forthcoming.
Good, and some credit to staff on that for sure.
They've had to push at the Goldbridge transfer station, that site. I was the one that initiated back in 2013 when I was the president of the Gun Lake Fire. to get that program going there. And they've had to actually push it back a couple of times now. Because there's so much that people are bringing in, but we're still getting road people putting it out in the various cut block areas and the salvage block areas, and they're still happening within our.
Yeah, you're always gonna get that.
Yeah, you're always gonna get it.
So is that
But
motion
I
clear
support.
enough, Angela? Okay, okay.
Okay, so moved and seconded.
I'll second it.
Moved and seconded, call the question, all in favor, opposed, motion carried.
And thanks for your help.
You saved it.
Thanks so much.
Okay. Correspondence for action, 9.1. Request for funding, Statly M Future Scholarship Fundraiser 2024 Golf Tournament.
The one I was stuck on. I was
Tony.
I want to make a comment about 9.1, 9.2, 9.3, 9.4, and 9.5. And 9.6, and 9.7,
Hey,
and 9.8. All of them except that request for tax exemption. And I want us to look at this when we're considering the whole way that EAD is structured and what authority we have and so on and so forth. I want us to look at this section of the agenda. I don't think any of these things belong in correspondence for action. I think they should be in the previous section for directors' reports. If they're in correspondence for action, I can see a situation where I get my agenda on Friday and I see on there a request for something. There's not one this month, but I see a request for something in area D. It's the first time I've seen it. And then I'm coming to a meeting on Wednesday. So I've got a few days to try and find out something about that. And I don't like that. I think that it shouldn't appear on the agenda. A request for funding shouldn't appear on the agenda until it's come to the area director and the area director initiates, putting it on there. There have been times when people have said to me, I'd like some money for this. And I've said, no, we can't do that. And we go through what they can do.
yeah.
And then by the time it comes here, it complies with our rules and limits. So I just want to make that comment now. I don't think we need to spend a lot of time discussing it right now because it will come up later when we have our, when we talk about terms of reference for EAD. But I look through these and some of them are addressed to SLRD, some are addressed to a specific director. I think staff, if they get something like this, it should go to the director and wait until the director brings it to the committee. So those are my comments. Thank you very much. I'll shut up.
I'm proud. Through the chair, we're not doing our job right if we haven't shared it with the director first. So please let us know when that happens. Our process is when these come in that they're shared with the director and the director requests for it to be CFA to the chair and we should copy on it. So I apologize if that happened because we're not doing our job right if you didn't know about it. And then for the other things, I think you're right. It's a conversation about TOR and EAD committees and it'd be good to just hear everyone's thoughts then, I think, talking about process when we get to that with the consultant.
Okay, thank you.
So this,
I guess the only thing I'd like to say is when we have the discussion about this kind of stuff, I don't want us to put something in place where it makes it more onerous for people to ask for funds from each director coming from select funds, amenity funds, whatever. Because if you've got the high school kids basketball association wanting funds, we don't want to make it so that it's a month-long process. Lots of times, it's just kind of a spur of the moment on a lot of these organizations' parts because something just came up and they need funding to get that going, right? So I think we need to make sure that whatever we put in place doesn't hamper them from doing that.
So that will be part of our discussion.
Yeah, absolutely.
That's fine.
This is really good stuff to capture, and I'm gonna ask her to listen to these few minutes at the next, when she goes through the recording of this meeting.
I mean, it's possible I'm in a minority. Good heavens.
Pardon me?
It's possible that I'm in a minority.
No, certainly, I've been surprised. Oh my goodness, this came from, and this is to do with Area B. I'm not sure who, right? Like, I would have liked to have spoken to them maybe, and so that I could speak to them. And so, you know, I don't like to just sort of blindly support or not support something.
I had one that showed up on a board agenda a while ago because it was addressed to Tony Rainbow Area D, SLRD. And so the staff judgment was this is addressed to the board, not to EAD. So first I heard of that one was when I got my board agenda. So it's just something for part of that whole process that we are going to be looking at, and I just wanted to raise it now so I can refer back to it.
Okay.
I just want to recognize that when we talk about process, we're talking about staff performance, and I want to be really careful with that. Meaning, so let's
No, I'm not talking about staff performance. It's just staff are doing what they think should be done. You know, they're getting something in and they're making a judgment, they're doing it. And all I'm saying is, then let's take a look at that and maybe give staff different guidance. That's not judging their performance right now. Okay?
Yeah.
Okay, I'd like to make a motion on item 9.1.
Oh, okay.
That we go with the silver, $2,500, and then it come out of general select.
I also, was going to suggest general select as well. I thought, because when I read the participants here in Quaqua, Sumaklun, Sekawash, Skateen, Tiket, Side, Squalex,
Everybody.
Haklip, Shalan, it's everybody except Lillooet, Nankuri. I don't see, this is representing 10 communities, stately and government services. I support this, but I just don't know the best way to.
I think we should
Funding and
support it and let them sort it out with,
In the next one, it's a Lillooet nation.
yeah.
See,
Because they're a different nation.
You also have the opportunity to just donate cash directly to the cause. That's on page 98.
So.
Okay, so you made a motion to do the silver, 2,500.
Yeah.
To come from general select, and you seconded that, did you?
Tony did.
Tony did?
Yep.
Okay. So it's moved and seconded. I'll call the question, all in favor?
Okay.
Opposed, motion carried.
Now we see the other nation.
Excuse me. 9.2, request for funding, Lillooet Nation, first annual Community School 2026 golf tournament. So.
Chair, I had a comment. I just realized the comment was about 9.1. They needed a check by August the 21st. So presumably we can still get them a check, but so I don't know when it was referred to this committee by the board, and I think that was.
Yeah, I think in cases where that's happened with me, excuse me, the money, they know the money's coming, or, I mean, it's all, taken care of in the wash, so to
Yeah, it's
speak.
very interesting because on Facebook, they've listed the sponsors.
They can't list us. We haven't.
Yeah, and yeah,
We
at the
listed
board meeting, staff was supposed to reach out and say that the funding is coming. So I'll leave it at that.
Okay, so we're on to 9.2.
Okay.
Request for funding Lillooet Nation First Annual Community School. I'm not gonna try to say that. Community School 2026 grad golf tournament. So this money would come out of then Area C select funds. And I'm gonna go with the platinum gold. I'm gonna go with the gold. 1250.
Okay. Through the chair, also wanting to mention that the tournament is May 29th, 2025.
Yeah.
So we may want to incorporate into the resolution that the funds be dispersed after January 1st, 20.
Yeah, for next year's budget.
Next year's budget.
Yeah.
Yeah.
Good plan.
Makes sense.
Okay, so I'll move that. Somebody will second it. Vivian,
Yep.
call the question, all in favor, opposed, motion carried. Thank you. 9.3, request for tax exemption, Permanent Wildlife Association, shooting range DL for, district lot 4096. So I will move this. Go ahead.
Is that something that is delegated to EAD, or does that need to be a recommendation to the
A
board?
recommendation to the board. Go ahead, Nancy.
Yes, thank you through the chair. It will be a recommendation to the board that staff prepare a tax exemption bylaw for 2025 in respect to the Pemberton Wildlife Association shooting range, and that the board will consider that if it is passed by EAD at the October board meeting. So
Yeah.
you'll see this come forward again through the board.
So, and then my next question to that was that this comes up every year.
Mhm.
Is that something we have to do every year, or can we do something for a 5-year package or something like that?
Thank you. Through the board, my understanding is that with tax exemptions, they do need to come forward on a yearly basis.
Well, yeah,
And
that's,
my third question then. No, I want to, this, because I've been thinking about that questionnaire we got about EAD and the discussions we've got coming forward. Is this something, again, that could be delegated to EAD?
I believe absolutely so.
So,
Yeah, that's my opinion.
but that's mine as well. So I just want to register that now, and
Yeah.
it will become part of our discussions later.
So,
Your first question there about can you have a 5-year? It would have to be a tax service change. And that would basically be a bylaw, and they'd have to get consent from the public to have it at that tax exemption all the time.
Suzanne?
We just went through that
Oh,
with,
Suzanne's here to answer the question.
yeah.
Suzanne, go ahead.
Yeah, so the permissive tax exemptions to go beyond annual, if you want to do 2 to 10 years, 10 years being the max, you do have to have consent of the constituents. So you have to go to petition or referendum to get that consent. So it's like a 3 to 6 month process.
I think we should look at that.
Yeah, I think that, yeah,
That's not, that's a very costly process to get an exemption,
is it?
not?
The staff time.
Well, if it's a costly process, then I say let's just leave it the way it is. Just get it into our jurisdiction. So when we pass it here, it's passed.
Yeah.
Yeah. Because I don't want to spend a whole whack of money and time and effort.
No,
Yeah. That's too bad. Because it just makes sense if we had a 5 or a 10-year exemption. That place isn't going anywhere. Pemberton Wildlife Association is certainly not going anywhere, so. Okay,
Chair, something I've been asking the Pemberton Wildlife Association for quite a few years now is what they're doing in terms of mitigating the lead from all these bullets, and they said they had some sort of a plan, and at some point, I'd just like to hear how they were doing with that.
well, the lead, most hunting bullets now, or even target bullets, they're not lead anymore, they're
No.
solid copper. So, the way that range was built and designed, the military built it for the Olympics. So it's all built to their standards. So they have a means of sifting it, cleaning it, all that stuff.
Okay.
And yeah, and so still the military, the RCMP, they all use that range for their practices or whatever, right? Or their qualifications. Because it's I guess a military certified range, right?
Okay, then I'll just withdraw
Yeah,
that question.
With the tenure, they actually have to have
Okay,
a lead abatement program.
good.
Yeah.
Okay,
No, that's a pretty yeah, a very good well thought out, obviously, facility. So moved and seconded. Did I call the question already? No. Okay, moved and seconded, call the question. All in favor, opposed, motion carried. 9.4, request for funding Ponderosa Community Basic Fire Suppression and Safety, the S100 training. Ponderosa Community requests funding of $1,500 to cover the cost associated with hiring a BC Wildfire Service endorsed instructor to deliver S100 training to the community members. And this is Ponderosa and McGillivray. And even they said anybody that wants to come from Darcy up into a limit of how many they have.
so this one, Chair Matt, I'd like to make a motion to pay that $1,500 from Area B select funds. Area B. Area D, and this is because I wanted some way to express my appreciation to Mike Morley and the crew there. They do a whole heck of a lot of work in supporting the Highline residents and fire prevention, which benefits Area B immensely in a very remote place. And so, yes, that's why I would like to do that from Area B funds.
First of all, I support this initiative, no question. The only question I have is that I'm kind of nervous these days about what the rules are, about what we can fund and what we can't fund. And so my question is that our regional fire chief, has he seen this and does it comply with the rules which we now must follow? Go ahead.
May I speak to it? I think it's a really good question, and it's something that we've talked about. For this one in particular, I'd recommend that a provision be added that they have joined to become the CCWR. So a provision that they are becoming part of a cooperative community wildfire response group. Having that provision in there will help support this and will also help us support if other funding models become available to pay for this training through BC Wildfire instead of coming through ours in the future. And I think we're in a good spot for that. That would be the recommendation.
I'm just curious on the community cooperative wildlife response, wildfire response. I think it was only initiated for the interior, specifically the southern interior. So I don't think that I'm aware of that it's in the coastal area at this time.
I can, through the chair, the recommendation from speaking to our protection services director and the fire chief is the hope that they join CCWR. So I'm going to go off their knowledge. I think we want to clarify this. We can refer it to staff to bring it back for recommendations, depending on the sensitivity of the timeline for this training. Because I don't want to say wrong. I also don't want to say staff or wrong.
And the other concern that I have with the community cooperative wildfire response program is, will they be doing the free training again next year? Or will they just, and it's a question to take back to staff, or is it just a one-time off where they wanted to get people signed up? And also during the 2024 wildfire season, how many of those community groups were actually engaged, brought on by BC Wildfire? I know that the Venable Valley Fire,
Mhm.
that Shelly Creek Fire, that BC Wildfire funded training for them. So I'm not even sure if they were ever hired on.
I don't think they
So-
got there.
Yeah, so, I mean, it's that whole conversation on the community, from the wildfire response program needs to get more clarified. Coming up, when is the meeting?
Oh, our wildfire roundtable?
Yeah,
November 4th.
November 4th, so it'll be brought up. And it's also, I think, part of the community forum, if it gets voted on to be one of the ones that talk about.
Well,
So-
we might not have the expertise at the community forum. We definitely will at the wildfire
Yeah.
roundtable. That doesn't help us today, though. Should we make it contingent on staff for the confirming or change to the resolution there?
Through the chair, we have a resolution drafted that we can be supported with. I also want to note Mark's comment that you recognize that the CCWR was a pilot, and it is the staff's hope that it continues, and they're pushing BC Wildfire Service on that decision and what their plan is.
Through the chair, I'll read out a potential resolution that funding of $1,500 be granted to Ponderosa community from Area B select funds, with funding subject to the Ponderosa community confirming they have taken the required steps to become a cooperative community wildfire response team if applicable, and subsequently entering into a financial contribution agreement outlining terms and conditions related to funds being used towards fire safety training for operating as a CCWR.
Okay, I hear you, I understand. Sounds like quite a bit of requirements to lay on this group, though.
Yeah, that's the problem I'm having with all this, and maybe that's where we're going in this world, but it just seems that we're putting so many, I don't know if you want to say roadblocks, or we're just making it so difficult for all these people are volunteers. And they're trying to do the best job possible, like this particular group with Mike Morley and his group. They work with BC Wildfire. The guy that's gonna come and do this is actually Vern Rasmussen.
Oh, wow.
So, I mean, that's who he works with all the
Top
time.
quality.
And he's a BC Wildfire guy, right? One of the head BC Wildfire guys. So he, it's just,
The BC Wildfire isn't paying Vern to do this.
no. He's gonna do this on a Saturday, come over
Right.
and do this program for
He's an
them,
endorsed
right?
instructor.
But
Yeah, is this program good? Absolutely. Should we be supporting volunteers who are putting themselves in a situation of risk? Absolutely, we should be doing that. But having said that, we have a regional fire chief who is operating under rules established by the province. And there are some things that sort of restrict what we can do, or we can only do them if certain conditions are in place. Which is all I was asking with this, and if we haven't got what's in place that should, what should be there, then we should pass a motion like this, which will ensure that they move in the correct direction. Yeah, we can argue other times about how it's too bad things are going that way. But, in the long term, if we're going to support fire suppression youth groups around the region, we have to make sure that they are operating in a way that is safe to them. Do they need the training? Yes, they do. But we need to make sure that everything is in compliance. So it used to be easier. Used to be less safe as well, I suspect. So,
yeah, it's the only thing, like I say, what's gonna happen is with all this bureaucracy coming into place, it's gonna drive people away, the volunteers, and that's a fact. So something that we'll have to deal with, I guess. It's gonna be harder and harder to
the
get
fact is
people.
that bureaucracy is there right now, and we have to deal with it. And we can't ask Rob to be doing things, or we shouldn't be asking our staff to be doing things that are not compliant with the new rules and regulations.
Yeah, but you know, Tony, maybe we need to be just standing up and saying those rules and regulations are going too far and they're making it more and more difficult for us to get people like in your Britannia Fire Department or Garibaldi or Whistler or Vancouver. It's a totally different story than it is in Sal's area or even in my area, right? Or Vivian's. When you get into these remote communities where it's all volunteers, it's people that live in the area that are providing their time and energy to do this. So we need to support them, and absolutely, safety is the number one priority. Absolutely. But I guarantee you, when you actually sit down and talk to the fire commissioner or people on his staff and stuff like that, they're wanting everybody to have the same level of training and such as Vancouver Fire Department or whatever. That's not gonna happen. Not gonna happen. So where there has to be a balance that like I keep saying, safety is the number one priority for all those folks out there that are doing it. And in my estimation, we need to provide them with the funding to get the training and the equipment to do their job. And they're not doing a full on, firefighting job as interior firefighters or whatever. And this is forestry related. So I don't know, we need to help them in any way we possibly can.
What they are is first responders to fires. To get it out before it takes off.
Yeah.
In the meantime, BC Wildfire's already been contacted and they'll bring the people out in helicopters to look at it and all the rest of bits and pieces of it. So the whole concept of these rural volunteer departments is to number one, identify the fires, report them, and action them right away before they get too big. They get too big, they're out. That comes with a little training. And down the road, if this community wildfire response actually gonna happen, because we don't know, because it's a pilot. And my understanding is it was just for the southern interior. And Mike Simpson was the one that started that program with BC Wildfire. And he's the one that works with what we're doing there. The round table. And the key to me is that they get trained enough that they can be work with BC Wildfire and actually have an agreement with them that they can go on Crown land and action these fires after they called it in. So that they're fully trained in what they need to do to be initial attack people. Because if you look at the community wildfire response program, what they do is they're going to be doing mop up and other smaller jobs. They're not going to be at the front line of the fire because they're not going to be trained up to do that kind of work. So to me, I'm okay with that motion as presented, because we don't know what the community welfare response program is going to look like.
Can I make a suggestion? Because we don't know the extension of CCWR, and yes, you're right, it was Area A and Area B this year with this offense. That we not have these caveats, and that we instead work on building strong relations to support organizations like this to become CCWR while we advocate for it to continue year after year.
That works for me.
And then once the CCWR is established, we then will be more strict, and the board might consider being more strict in these requests. So that suggestion.
So in that case, then,
We would still need contribution agreement just because we need to do those, but it wouldn't be restricted to CCW work.
okay. So then the resolution will read to support Ponderosa community with $1,500 from Select Area B. Cover the costs associated with hiring BC Wildfire Service endorsed instructor to deliver S100 training to the community members. Contingent on a contribution agreement. Okay. And I think that'll be fine if it is along the lines of what we just did with the Yalicum. Hopefully, though, it won't take a long time to develop that contribution. Okay.
We got that done.
And then if we're in agreement on the resolution, then that's what I'd like to move.
Just one final comment from me, because I know you look at me as being this lucky person that has these two wonderful fire departments at Britannia and Garibaldi. And yes, I do, and I appreciate them, fantastic. But I also have this little group of people up in the Upper Squamish who are struggling to do things and wanting some support, and I can't just give them money at the moment because of various rules that we have to work within. And yet when there was a fire in a building there's a couple of them up on the roof fighting that fire, you know. So yeah, we got to do something out there, and I just want to make, and I'm working with Mark on what we can do when we can do it. Unfortunately, there are some rules there, and so if staff are comfortable with this agreement now, and then fine. That was all I was asking about.
No, there's a motion before I can talk. Let's remove that.
Okay, moved and seconded. Call question, all in favor, opposed, motion carried. Thank you. 9.5, request for funding.
Yeah, I'll have to call
Okay,
declare a conflict of interest. As my wife is on the board of the BRC and my daughter is a paid employee.
May I ask a quick question? Is that going to be true for 9.8 as well?
Yeah, and I'll declare for 9.8 if you can do them together.
That was what I was going to ask.
Through the chair, you can certainly make a motion to adjust the agenda and move 9.8 to be heard after 9.
so they're back to back.
Yeah.
Yeah, let's do that.
So I'd like to
I'll
move
move that.
Okay, Tony was moving it, so we're
Okay,
So I'm also declaring a conflict of interest for 9.8. As my wife is a director on the board of the BRCA and my daughter is a paid employee.
so we've moved 9.8 right up against to 9.6.
Yeah, right after.
Yeah.
that.
Okay. Request for funding, Bridge River Valley Community Association, River State 2024.
I'd like to move Area A select funds in the amount of $610 for a memorial wreath, community tea, staff time, and advertising as outlined.
I'll second that.
Okay, seconded. Okay, moved and seconded, call the question, all in favor, opposed, motion carried. We go to 9.8. Request for funding, Bridge River Valley Community Association Economic Development Committee, draft community economic development plan.
Okay, I'll certainly move. I'm confused. I'll have a question after this, but in terms of the $8,080, I'd like to move that from electoral A select funds to cover the overage costs of developing a draft community economic development plan for the Bridge River Valley Community Association.
I'll
Okay,
second that.
moved and seconded,
You have a question?
call the question, all in favor, opposed, motion carried.
Yeah, good. My question was moving farther down, and Sal should probably be here for this part. Just to get it on the record. Oh my goodness. Where was that? Page 1. Oh, he's coming back. Or no, the next one is pavilion. So page 122.
The next one is actually,
Lillooet Learning.
Little
Oh.
Learning Communities Society Truth and Reconciliation Initiatives.
Right, right.
Okay, we're ready for that one then?
Just, I want to say one more thing about the Bridge River Valley Community Association request. Because it goes on quite a ways,
Yeah, because I'm here.
He's here.
No, well. It's something that I want to keep, okay, all right, we'll leave it be.
Okay, request for funding, Little Learning Community Society Truth and Reconciliation Initiatives. Little Learning Community Society requests funding up to $5,000 to host 2 community conversations around truth and reconciliation and design and publish a coffee table book summarizing the learnings.
So the request is for more than $5,000.
Up to.
No. Looking at this request. Isn't there 10,000 as well? Yes,
10,000, just.
in support of sharing the outcomes and so forth, right? So,
1, 2, 3, fourth paragraph, fifth paragraph, and fourth paragraph.
so I wanted to contribute where's the 5,000? I thought I had 5,000 plus 10,000.
It's the sentence right after number 5. It's going up. Right here.
There. So I wanted to move 15,000 from Area B Select funds towards these sessions as outlined, and also towards the book that they're putting together. Without Lillooet Learning.
I'll second it.
Okay, moved and seconded. Call the question, all in favor, opposed, motion carried.
Yeah, it's pretty neat. They've got some really good things happening here.
That's a good initiative.
I'm thrilled to be, I'm sorry to be stumbling. I thought I had this. I knew what the request was. I just wasn't finding it on the page. Sorry about that. No, that's okay.
I up to 5,000 funds from this.
Okay,
So-
request for funding, Pavilion Lake Residents and Property Owners Association, Emergency Response and Protection Equipment. Pavilion Lake Residents and Property Owners Association requests funding of $6,533.20 for the purchase of fire protection equipment.
And we've had a late addition to that request, which I sent out on the email, which adds $987.06 and $1,085.63 for further equipment. I'd like to support those 3 amounts. I haven't done the math in that all.
So my question is the same as previous ones about fire services. Where does that fit in with the rules that we have to play by?
Yes.
Thank you, through the chair. Good question, and we are seeing situations where community groups are very focused on the response phase and would like to encourage the preparation of attention, so fire smart, and then the training, and then equipment for response. We recognize after the fire services review, and the next step here is to work on a policy so these decisions are clear and we can mandate how we decide on this. In this case, my recommendation would be to refer it to staff and to discuss with Pavilion Lake regarding it. They have been selected as a CCWR.
Yep.
To the best of our knowledge. We could also pass this and include a contribution agreement that outlines
Yes.
that they be a CCR and that we have proof that they are meeting the minimum requirements for that. And then there's no need to come back here right now. So it could also be a motion with a contribution agreement with those caveats.
I think, let me just read it again. They're also looking for training, right? So, if there were funds available before they become CCWR, because they have to get trained.
Mhm.
So we don't know if they've been trained to that program. So if they are trained, then they're probably ready to go. So but if they're not trained, they may not be any training next year. Retraining, so there should be something in there where the training can happen anyway. So money for training should be part of this.
I was busy
Just my
doing the
thought.
math, trying to add up these three amounts, and I think the total is $8,605.89 for these three. Just for the resolution.
Through the chair, would you like to increase that to ensure we have an up to amount that has some room for training?
Sure, that's a really good. idea.
10, up to
So up
10.
to $10,000, is that, can we work with that? Thanks, that would be great.
And the training can be done prior to anything. No, it needs to be done.
We feel like we have enough of a motion.
Yeah, definitely. Thank you. Yeah, and through the chair, we will have an up to amount and we will list to include safety equipment, training, and as well as metal sheeting for the fire hall.
Perfect. So moved.
Is that enough?
Yep, I think so.
Because you're at 8.6 already before the training, right? So that leaves 14 for training.
The previous one was 15 for training, so.
Yeah.
It was in the
It's
range.
close.
Yep.
It was costing us, cost of PRBCA roughly, the training program, roughly $3,600. The instructor came from the Vancouver Island certified BC Wildfire Service. So if you can get somebody from Lillooet,
I'm sure we can.
you cut the cost way down.
Yeah.
Okay.
Burn.
Yeah, there you go. All right, moved and seconded, call a question, all in favor, opposed, motion carried.
See, we've arrived at a good place.
Pardon me?
We've arrived at a good place with this. My comment earlier was that this came to, and again, I'm not criticizing staff because that's what they're supposed to do, but I'd like to change what happens. If something comes in with to the attention of an area director, before it goes out to the area director, Vivian could have had some conversations with Mark, with the Pavilion Lake Residents Association, and it could have come to us as a complete package, rather than us sort of messing around here trying to put it together. And
Well, a lot of this came to me last minute too. So I'm not, I'm not sure how much time I would have actually had to. And as far as I knew, Marcus was still away, so I'm glad he's back, but I get your point. But there's also the reality of dealing with these volunteer groups that do tend to use, they're working to the last minute, and so sometimes we don't have as much time
no,
in
I
anticipation.
get that.
Yeah,
Okay,
great.
so do we have anything else now, or?
Where are we at? Tell me where we're at.
Well, we just went past 9.8. So we're at
Decision on lake business.
decisional link business.
So one request, if I may, I have something which will take me 1 minute to do, which is to present some information to you.
66.
What's the vote on this side? Okay.
We need, sorry,
We
through
have
the
a
chair,
motion.
we will need a motion to, when we know the item, we can add it as late business 11.1 if it passed by the committee.
Okay, the item is to do with my area D discretionary select.
Discretionaries. Okay.
I
Can I get a
would like to
motion
make
to
a
add?
motion to add that as 11.1.
7.1.
I'll second
Area
it.
D discretionary select.
Okay,
Second,
moved and seconded, call the question, all in favor, opposed, motion carried. Go ahead, Tony.
Oh, okay. I've got a plaque for the house down Biosphere region thing. I've never been able to get it mounted. We needed a rock, couldn't get a rock anywhere. It was moved, pardon?
We've got some rocks.
We've got tons of rocks. We've got tons of rocks. Most of them are too big or they're round and we need a nice flat one. So I actually went and found a rock at the Northwest Landscape Supply Limited, and they wanted $500 for it. I got it for $293.41. And instead of waiting for several weeks, I thought I'm going to pay for it right now out of my discretionary fund, which I'm required to then report to you, which is what I'm doing. The reason I wanted to do it right now is because I put it on my monthly expense claim.
Preemptive strike.
Okay, thank you. That's it.
Wait, we haven't approved that.
Pardon?
And you're just informing us of that.
That's all I'm required to do.
Oh.
With the discretionary, that's what it, discretionary amount means. We have the
You
discretion.
don't have to have permission.
Don't need
Okay.
permission, but do need to inform.
Yes,
So which
thank you very much.
Thank you.
We are informed. Okay, any more late business?
No, I'm
No.
done. Thank you.
You're done?
Yes.
Okay. Late business, fine, we've done that. Director's notice of motion,
No, nothing there.
none there?
Are we on 13?
Tony's favorite.
I'd like to
Right
move
now.
adjournment, please. Third word, the rock out.
Well done.
Expensive rock.
Thank you very much for that.
Do we have a second for adjournment?
All right, is anyone opposed to adjourning?